The House will come to order. Members, when we went into recess, we were on the Scott Amendment, the A15. Representative Zalesnikar had the floor before Representative Nash did a call of the House. So Representative Zalesnikar.
Thank you, Madam Speaker and members. The A15 amendment is giving women the assurance of safety and remembering women who have been raped and molested and have had horrible events happen in their life, to know that there are spaces in our life that should be able to be separated for people to feel safe and secure. And while we might not understand it, and we can all be in this space like this, in the spaces of prison and domestic abuse shelters and locker rooms, I think it's important for us to be able to acknowledge the reasons why having separate spaces in some moments of our day and our life might make sense. I come back to thinking of times that were simpler than right now today in 2024, when it would never take hours of discussion to be talking about how we're going to define what a federal ERA once looked at that was just simply on the account of sex. And so while this amendment, the A15, allows us to assure safety, it's really highlighting the need to have equality for everyone. For your little girls, for your wives, for your sisters, and whether you want that or not, to have enough understanding to acknowledge that maybe somebody else does. And so when we're expanding and adding an expansion of rights to this federal ERA that lists many, many things, it can't be at the expense of forgetting about the safety of others and what that looks like. And again, if one negative outcome happens, it's one too many. If it's your sister, if it's your daughter, if it's your wife, if it's your partner, if it's your mom, it's going to matter. If it's your neighbor, those women matter too. And so these are conversations we didn't have to have before, but it's 2024 and here we are. And so it's not just sports, it's not just Title IX, it's not just age, it's not just religion, it's also being able to have the assurance that our safety is going to be protected in all situations, knowing that I was born with the muscles and the lungs and the bone capacity that's only going to look like this. And we all come in different shapes and sizes. And that in its very self makes people feel like they're not safe sometimes. My mom's 90 pounds, and she's 5'4". She's a tiny little peanut, but she's pretty darn feisty, and she's pretty strong. But I'm quite sure that if she was in a domestic abuse shelter or needed to be in any of these places, she would want to have those provisions. And regardless of age, I think most people do. At least to have the ability to know that it's not something you have to fight for to have. And these basic rights for women have been fought for long before ERA came. And here we are in 2024 having to carve out a special A15 amendment that would assure something that's been a fundamental thing we've all just assumed would be a given in 2024. It's hard to believe that you'd have to think that's not a possibility in 2024, to have your safety be protected. That in a domestic abuse shelter, in a rape center, counseling center, a prison, a YMCA, that the state of Minnesota is going to have your back. If you're the 90-pound, 5'4", any age woman, that you're not going to have to worry. That you're not going to have to worry about that in 2024. So members, as we debate this topic, let us remember that as we put new rights in a constitution, we're talking about a constitution amendment. So whatever we think could happen for interpretation, it doesn't matter what we think. A constitution is going to put it stamped, sealed, and delivered, and we have to be able to all live with it. And so our rights, we have to know for sure that they're going to be protected. Everyone. Equal rights is equal rights for everyone. That means me. If I'm in a rape center and I don't have the same beliefs as somebody else does, that I'm going to be safe. I have the right to expect that in the state of Minnesota. And whether or not you think it's reasonable, I still have the right to want to have that. And so do other people. And so I think we need to think about the federal ERA, and what it was really talking about was pretty clear back in the 70s, and today it's not. It's as clear as mud of how it's going to actually play out in a constitutional amendment. And there will be court cases. And do we have to wait for a court case because an event took place? I would hope not. So members, please support the A15 and have some guardrails for reasonableness, for places where you're undressing, where you're naked, where you're sleeping in a cell, where you are going to want to know, or you've been abused, or you've been raped, or you have a life story that maybe doesn't match all of us in the room. It could be different. And they're very painful moments for people, that we honor that on however we shape public policy in a Constitution amendment. And I hope that your hearts will be aware of how this is going to shape it for your daughters, your wives, your friends, and your neighbors. And for the future generations to come, because the Constitution Amendment is not just for us in this chamber. It's for my future grandchildren, boys, girls, it's for all of them. This applies to us all. And I hope history is going to show that we stood for assuring safety for our boys, for our girls, for everybody. I hope you'll vote yes for the A15. Thank you.
The member from Isanti, Representative Johnson.
Madam Speaker, members, I hadn't planned on speaking on this amendment, but I had to. But first of all, I want to congratulate Representative Gilman on 30 years of marriage. Unfortunately, that doesn't happen as much anymore. It's too easy when times get tough to just walk away instead of try to work out the problem. So congratulations, Representative Gilman. Now, the A15 amendment, it does what our Constitution tells us to do. Our current Constitution. Article 1, Section 1. The government is instituted for the security, benefit, and protection of the people. Now, of the people isn't one person or one group or another group. It's all the people. And all the people deserve equal rights. Not giving special rights to certain groups or certain things, but all the people, every single one of us. And for me, I believe that's from the womb to grave. Now, we also have a obligation by our Constitution, and that is to protect everyone, every person in this state. And it's to do that, we have to do our best to keep every person from being a victim of a crime. That's what this amendment does. It gives some space, some privacy, a right to privacy for those who've already, a lot of times, have already been a victim of a crime, to make sure they're not abused or taken advantage of again. That's why this amendment is important. Members, please support the Scott Amendment. It's the right thing to do. It's the proper thing to do, and something that we must do by our Constitution at this time. Vote yes on the amendment.
The member from Anoka, Representative Scott.
Thank you, Madam Speaker and members. Thank you for a really good conversation about the fact that women and girls need safe spaces. It should be something that we really have to debate about. I'm wondering if the author would yield to a question, Madam Speaker.
She will. Representative Scott.
Thank you, Madam Speaker. Representative Herr, is it the legislative intent of your bill that there be separate places, accommodations that have sex-based distinctions?
Representative Herr.
Madam Speaker, Representative Scott, it is the intent of this bill, because it is a constitutional amendment, that state actors operate in a way that is in line with what is outlined in this particular bill.
Representative Scott. Members, I would remind the body that we are on the A15 amendment. Representative Scott.
Yeah, thank you, Madam Speaker. I'm not sure what that answer really was. It seemed fairly circular. Would Representative Herr yield to another question?
She will. Representative Scott.
Thank you, Madam Speaker, excuse me, I'm so tired. Representative Herr, I have here from the Department of Administration, there's a grant program, a couple of grant programs out there, and the people that can apply are Asian Americans, African Americans, Hispanic Americans, Indigenous Americans, women-owned businesses. All these are like businesses that are owned by these people, various minority groups, and the disabled. And so I'm wondering, under your amendment, do you think that the ERA could possibly dilute opportunities for biological women in this respect?
Representative Herr.
Madam Speaker, Representative Scott, I would just like to draw the body's attention to lines 2.7 and 2.10, that this section is self-executing. It does not limit or narrow existing rights in the Constitution. Nothing in this section shall invalidate or prevent the adoption of any law regulating programs, practices, or benefits designed to prevent or remedy discrimination on the basis of characteristics listed in this section. And so the current programs in place that it addresses communities that have experienced discrimination in the past, it should not impact those programs.
Representative Scott.
Well, thank you for that fairly direct answer. I really appreciate that. One of the things that was stated earlier was that, and this was from the bill's author members, was that if the state laws allow for this amendment, the A15 already, and I'm going to question that that's already, that this language is really already in law. Because Anoka Hennepin schools were sued over a biological male who wanted to use the women's locker room. And so if the amendment is already allowed for in law, then how was this lawsuit, what was the basis for this lawsuit then? Representative Herr, if she would yield, Madam Speaker.
Representative Herr will yield. Representative Herr.
Representative Scott, that is all. I guess I'm confused by the question about passing a law that will impact something that is already governed by current laws right now. So I guess if you could clarify, if you're trying to ask me to apply this retroactively, how would it impact the situation? I guess I just want to try to understand the question that's being asked, because what is in place right now is in law, and that is what is being challenged. And when this is passed, because this only applies to state actors, whatever situations that are being litigated right now, those things will continue to be depending on their circumstances and situation. So I guess I just want to make sure I understand what you're trying to ask me about if this gets passed, how it gets applied for things that are getting litigated right now already.
Representative Scott.
Thank you, Madam Speaker. Representative Herr, earlier you said that my amendment wasn't needed, that there are already laws protecting what this amendment is trying to protect. But my point is, if that's the case, then how could it be that the lawsuit brought by two Anoka Hennepin schools, it shouldn't have had any standing in court? I'll move on. I'll move on. And Representative Ryer, is she on the floor? Yes. Representative Ryer, I'm really sad to hear that you spent time in a women's shelter. That's, I don't know what that would be like, and I'm really sorry about that. But one of the things you did was you read from the Constitution, and you said that there is nothing in the Constitution saying that trans people don't have rights, which is correct. There's nothing in the Constitution saying they don't have rights. I thought that's why we were, why are we here then? What we're trying to establish here, folks, is that there shouldn't be a hierarchy of rights. Everyone, and this is what Republicans believe, they believe in equal rights for all. We don't believe in a tiered system of rights. All means all. Equal rights must include everyone. Folks, today, I'm guessing that some of you have been receiving emails and phone calls into your office about this upcoming ERA. And I've gotten quite a few myself. In fact, I got one today, and I wanted to read parts of it. Dear Representative Scott, my youngest daughter recently joined and I won't tell you which the swimming club it is, but she recently joined a swimming club. And the mother goes on to say, it's terrifying to realize our daughter's dream of joining a swim team is hinging on the fact that a biological male can invade the locker room of not just our child, but that of many, many other girls. She said, the rules in swimming are endless, to the point where parents cannot take video or photos during practices and meets, yet a biological male could enter a female locker room? Say nothing about the inaccuracies of a male competing against a female. Outrageous. She gave me a link to all these different rules that exist to be on this swim team, on this swim club. It says the rules are endless in sports, but where are the rules protecting our daughters? Folks, Minnesotans are watching this. They're watching this debate probably more closely than I've seen a debate of this nature, a cultural sort of thing, be debated. And they're weighing in. And it doesn't make sense to them that we would be doing something like this in the legislature. We've gone over this a couple of times, that Minnesotans need to know what they're voting on. That's what we're trying to establish with this debate. 64% of Minnesotans believe that questions of equal rights, and we haven't gotten to the abortion issues yet, and unlimited abortion up to birth should be separate questions. We cannot have, as Representative Ann New Brindley said, we cannot have this tiered system of trans rights up here, trans women, and then the rest of women. That is what this amendment is establishing. I want to end by reading a paragraph from an article that I came across by Helen. Let me find it. Too long of a period of time off here. Here it is. Helen Joyce, and she wrote an article entitled "The Trans Movement Wants to Take Away Women's Rights." And this was from August of 2021. But I thought what she had to say was really interesting here in the last paragraph. It says, it's all become about gender self-identification, which is this idea that all of us have an innate thing inside ourselves, a kind of sexed soul. This, and not our biology, is the thing that makes us a man or a woman, or possibly something else, non-binary or gender fluid. If that's what you believe, you have to rearrange everybody's rights. Because some of our rights are sex-based, like the right to single-sex accommodation or sports. If you rearrange the world so that everything is done according to what people say they are, you take away rights from the people who want it done according to their sex bodies. I thought that was so well said. Members, please, I ask you to have some common sense here. Protect girls and women in safe spaces. Please vote green.
The clerk will take the roll on the amendment. Will the clerk please call the name of the member voting remotely?
Carol.
Carol, no.
Carol, no.
The clerk will close the roll. There being 62 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
New Brindley moves to amend Senate File Number 37, the unofficial engrossment. The amendment is coded A28.
The member from Chisago, Representative New Brindley.
Thank you, Madam Speaker. So the A28 amendment is really about what authority the legislature will have if this amendment passes. And it simply says that nothing in this section prohibits the legislature from regulating health care, including but not limited to gender-affirming care and reproductive health care. And I want to talk about this for just a minute because I actually think that this is a really important piece. Last year on the House floor, Democrats passed the PRO Act, which enshrined into law the most radical abortion policy in the country, allowing for abortion for any reason, at any point in pregnancy, via any method. That's what was enshrined into law 1 year ago. But that misses the boat, and we want to ensure that the legislature still has some authority here. And I want to give some examples. Number one, and kind of an easy one, is I was thinking about an amendment, and I think a bill that Representative Scott carried previously. And it was a requirement that a chemical abortion needed to be administered in a facility where a woman receiving an abortion had contact with a healthcare provider, had direct contact with the healthcare provider. And I immediately signed on and said, I'm on board. This is really important. And let me tell you why. 16 years ago, this summer, I had an experience. This is why I know how important this is. 16 years ago, I had an experience. I was pregnant and miscarried. I miscarried that baby. It was early in pregnancy, but I had a miscarriage. And things seemed to be going fine. It seemed like my body was just readjusting after having a miscarriage. And however, let me be very clear. After I had this miscarriage, had the miscarriage at home, this was my 6th pregnancy. Frankly, I didn't think much of it. This was old hat to me, frankly. And so I didn't think much of it. Everything seemed okay. I didn't bother to go to the doctor to ensure that everything was okay. And 2 weeks later, I happened to be just down the street in Regions Hospital, visiting a friend, and with another friend. And as we were leaving, I told this other friend, you know, I do not feel good. Can we just go back down? I just want to go to the bathroom real quick. And as soon as I said that, I started blacking out. And the world started spinning, and I blacked out in the hospital. I could still hear I was still standing, but I blacked out. And we got to the main level. I saw a chair across maybe 10 feet away. I went to sit in it. Kathy got a wheelchair. She found one quickly. I sat down, and Kathy said I just immediately slumped over in the chair. And fortunately, we were in Regions, like, right down the hall. We were literally feet from the emergency room. So I was able to receive medical attention immediately on the spot. And we got to the ER, and they put a blood pressure cuff on me. They told me, I forget what the word is, recall from my college days, but hyper or whatever, I was sweating. And I said, what does that mean? And she said, you're sweating a lot. And as soon as she said that, I could feel sweat coming from every pore, like on my legs, everything. My body was trying to dump fluid to get my blood pressure back up. And Kathy, the friend that was with me, said that they ripped the blood pressure cuff off, said code something, and she said the entire emergency room stopped, and everybody went to the room that they were taking me. As it turns out, 2 weeks later, I had an ectopic pregnancy that ruptured. And I never bothered to go to the doctor after that miscarriage because I thought, well, it's fine. This is normal. It happens. I didn't realize how important it was that I go to the doctor, that I have an ultrasound, that they make sure that all the tissue passed properly, that I was going to be okay. I didn't realize how important that was. But by the end of the day, my symptoms were very odd. It's actually unusual, I had no idea. It's very unusual for an ectopic pregnancy to grow large enough to rupture because it's super painful. And so most women go to the doctor before that happens. For whatever reason, I had a high tolerance of pain. I don't know. I didn't know. I had no idea. But by the end of that day, my symptoms were presenting odd, so they couldn't do a laparoscopic surgery. They had to open me up, do a double tubal ligation. I had hematomas on my ovaries, and I had lost 1.5 liters of blood which is a lot of blood. And all that happened because I did not know. I know it sounds so silly. Again, 6th pregnancy. I should have known better. But I did not know how important it was to go to the doctor, to have an ultrasound, and to make sure that everything happened as it should have. Because had I done that, had I gone to the doctor after that miscarriage, after that spontaneous abortion, had I gone to the doctor, they would have known immediately that I had an ectopic pregnancy. And that fallopian tube never would have ruptured. I would be intact today, likely. I tell this story because there are reasonable things that to legislate to ensure the safety of women. A chemical abortion is not without risk, the biggest risk of which is not passing everything properly. And needing follow-up surgery, etc., after the point. But there is real risk for women in this. So when Representative Scott had that, I immediately understood the wisdom, understood exactly why this matters, and signed on. So that's just one example of why we need to make sure that nothing in this section prohibits the legislature from regulating. I look at things like, at the federal level, there is a ban on partial birth abortion. Because aside from here in Minnesota, as a society, nearly everyone has agreed that there is absolutely no reason to allow this absolutely barbaric practice. It's absolutely barbaric. And in fact, there's a federal ban on partial birth abortion because of that. And that ban actually has stood up to judicial scrutiny. In 2007, it was upheld. And here in Minnesota, we should have the option of ensuring that that doesn't happen here. On the flip side, I was reading through the governor's executive order on gender-affirming care. And in that executive order, the governor actually cited a study on gender-affirming care, medical gender-affirming care, showing that over 13% of transgender people who receive gender-affirming care chose to detransition. This was a study cited in the governor's executive order. You can imagine how surprised I was to see that there. And that number amounted to 2,229 people out of 17,151 who chose to detransition. That was in the governor's executive order. That's actually where I found that study cited. Understanding the lifelong effects of medical gender transition that cannot be undone, it is reasonable to think that a future legislature may have even more information than we have now, and that it would be prudent to have legislative insight into how this is applied. That perhaps medical gender transition for minors and the lifelong irreversible changes are not prudent. And as a legislature and as future legislatures, not only should they have the right to ensure the safety of all Minnesotans, they have a duty. They will have a duty to ensure the safety of all Minnesotans. But let's be very clear, right now, in this underlying unequal rights amendment, as drafted, there are no limitations, there are no guardrails for abortion or medical gender transition. Not for kids, not for women. No measures to ensure women are safe if they do choose to have an abortion. No measures to protect children from lifelong decisions that they may not really understand yet. And so, members, we have a duty as a legislature to ensure that future legislatures have the ability to perform that duty, to use the best information they have at the time and make decisions to ensure that women and children are safe. Madam Speaker, I would ask for a roll call vote on this.
Representative New Brindley requests a roll call. Seeing 15 hands, there will be a roll call. Representative New Brindley.
Thank you, Madam Speaker. And members, I would request a yes vote on this.
Discussion on the New Brindley amendment. Representative Herr.
Madam Speaker, Representative Brindley, and Representative Brindley, thank you for sharing your story. I can't imagine how painful that might be, and I think that you and I think I would consider you a friend. You and I talk a lot off the floor too, and I think that this is one thing that you and I actually share very much in common. I've actually shared this story in the past before, that my first pregnancy was an ectopic pregnancy, except for because it was my first, I was spotting, and I went to the doctor, and they told me it was an ectopic pregnancy, and I did have an abortion. I had an abortion to save my life. And so I think that it is really important that government does, continue to be able to regulate health. The legislature continues to be able to regulate healthcare. It currently has that right now to do that. And the passage of the ERA, it doesn't change that. So government will continue to regulate healthcare. However, if that regulation violates someone's rights, it requires the state to use the least restrictive means of achieving a compelling governmental interest. So again, this is constitutional standard law. This is constitutional law standard, and so I recommend a no vote to this. But I want to again say thank you for sharing your story, and I think that we all have to be able to make the choices best for our bodies and what we are experiencing in our life, and that's a decision between us and our doctors, and that government and our state continues to be able to, the legislature continues to be able to regulate that, and nothing changes again with this passage of the ERA. So I recommend a no vote.
The member from Hennepin, Representative Robbins.
Thank you, Madam Speaker, and thank you, Representative New Brindley, for bringing this amendment. So I want to go back first to the point that we have a very robust State Human Rights Act. And what we're talking about now is a constitutional amendment. And the State Human Rights Act is very robust, and it includes all of the categories in the constitutional amendment, and it also includes age and religion, which the constitutional amendment does not. And the reason the New Brindley Amendment is so important is because, as we talked about before, it raises the court's treatment of gender and sex from intermediate scrutiny, which is the mid-level, to strict scrutiny. It will be much harder to prove a compelling interest than current federal and state law allows, because they acknowledge there are actually state interest reasons for treating sex differently in some situations. So this science of hormone therapy and gender-affirming care is really evolving. And putting something like this in the Constitution without the New Brindley Amendment would make it really difficult at the highest level of scrutiny for the state to pass laws that are following science as it develops. So back when the Obergefell decision was made by the Supreme Court in 2015, not that long ago, 9 years ago, the court held that psychiatrists and others recognize that sexual orientation is immutable. That was the standard. Since then, many people have come to believe, as was articulated on the floor tonight, that there's a continuum and that your gender identity can be chosen, it can change, and so it's not settled at all members. And so there's a lot of effort going on around the world to think about what's the best way to provide gender-affirming care. And the experience of our friends in Europe who are ahead of us on this is that they are pulling back. So they are passing laws that if we adopt this amendment without the New Brindley Amendment, that we would have trouble passing. And what they're doing in Europe is they are pulling back on gender-affirming care for minors because they are very concerned about the health, physical health, psychological health implications of making life-altering decisions like this. So, and interestingly, it's not that political there. As I was reading some articles, they said, these laws aren't being pushed by legislators. It's not politicized like it's in the US. The institutions are changing it based on the level of medical risk they see. So, so in Sweden, Norway, the UK, they have all significantly reduced the gender-affirming care for minors. Age is not in this. So a law that we pass to protect minors from life-altering harm as the science develops might not be workable under this constitutional amendment. In Sweden and the UK, they've changed hormone treatments for minors only for research purposes. You cannot get them from your doctor anymore. In Norway, they've said that gender-affirming care such as puberty blockers are now defined as experimental. And in France, in February of 2022, their National Health Alliance recommended greatest reserve when considering puberty blockers or hormone treatments due to possible side effects such as impact on growth, bone weakening, risk of infertility, and other complications. So while we in the US are forging ahead to allow minors to make these life-altering decisions, people who have been on this path longer than we have are putting the brakes on. And if we do not adopt the New Brindley Amendment, we will be severely limiting ourselves and future legislators from passing laws in the best interests of children in Minnesota who could be forever harmed by treatments that are experimental. Members, the New Brindley Amendment is just common sense. Please vote green.
The member from Goodhue, Representative Altendorf.
Thank you, Madam Speaker, and thank you, members. I need to clarify something because unfortunately, one of the things that I believe the Democrats, the majority party, talk about is ectopic pregnancies and that they are abortions. And that is just not correct. And in fact, there is no state that does not allow a woman to treat, I'm sorry, I gotta pull this up here a second, an ectopic pregnancy. Just to quote here, so from Texas state statute, an act is not an abortion if the act is done with the intent to save the life or preserve the health of an unborn child, to remove a dead or an unborn child whose death was caused by a spontaneous abortion or a miscarriage, or to remove an ectopic pregnancy. And I just think it's really, really unfortunate that we are using these scare tactics, that we are telling the public that they have to have an abortion provided to them, or that they could not have an ectopic pregnancy, or if they had a miscarriage, that would be considered an abortion. It is not. It is not. It is not, and it's really quite disgusting that we are characterizing it that way.
Representative New Brindley, closing argument.
Thank you, Madam Speaker. I hope that folks will see the wisdom of this amendment. As Representative Robbins said, it's not just as easy as Representative Herr would lead us to believe that we have the right. Everything will continue as is. Government will continue to have the ability to regulate health care. This unequal right amendment changes that significantly. And we do not want to hamstring future legislatures from implementing not only current information, but perhaps new information that we don't even have right now. We want to ensure that legislatures always have the ability to make the very best decisions for the time that they are in. And I would request a green vote.
The clerk will take the roll on the amendment. Will the clerk please call the name of the member voting remotely?
Carol.
Carol, no.
Carol, no.
The clerk will close the roll. There being 62 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There's an amendment at the desk. The clerk will report the amendment.
Perryman moves to amend Senate File Number 37, the unofficial engrossment. The amendment is coded A25.
The member from Stearns, Representative Perryman.
Thank you, Madam Chair. My amendment, A25, simply clarifies the new section of the Constitution does not require the expenditure of public funds to address previous discrimination. And let me explain that. Within SF 37, there is a disclaimer contrary to the stated intent of the proposed amendment to guarantee equality under the law. This provision 2.8 to 2.10 allows laws, regulations, programs, or benefits designed to prevent or remedy discrimination on the basis of the characteristics listed in this section. This section allows spending programs, intended to benefit women or communities of color would not be unconstitutional by the very same section. However, the concern is this new section of the Constitution will be used to force the state to enact and pay for programs to remedy previous discrimination. So this is just a few notes to explain what I'm saying here. This amendment would ensure that judges do not feel compelled to require public funds as a remedy to violations of this provision. It limits judges from making broad public policy decisions that have a fiscal impact without legislative approval. It is a protection of the separation of powers. And it is not a ban on the award of public funds, and it is also not a requirement. For example, one-time damages award could be provided, but not necessarily a mandate of public funds via some new remedial policy. Members, I really will ask that this be considered. It's a simple amendment to, the current SF bill, and very simple and just very good clarification. Why wouldn't we want to clarify it? And members, I ask for a green vote, and Madam Chair, I ask for a roll call.
Representative Perryman requests a roll call. Seeing 15 hands, there will be a roll call. Discussion to the A25 Perryman amendment. The member from Ramsey, Representative Herr.
Madam Speaker, Representative Perryman, and Representative Perryman, thank you for coming to talk to me ahead of time around this particular amendment. I just do want to just repeat what I said to you, is that the substance of remedies is actually not discussed anywhere in state constitution. There is one Section 8 in our Bill of Rights that talks about redress of injuries or wrongs, but it doesn't specifically state like what the remedy would be. And so for this to be placed, it would be the only thing in our Constitution that would actually state the remedies, and so I'm going to ask for a no vote from the body.
Discussion. The member from Anoka, Representative Niska.
Thank you, Madam Speaker, and I have a follow-up question for the author, if she will yield.
She will yield. Representative Niska.
Thank you, Madam Speaker, and Representative Herr, in the Rules Committee hearing, I believe you were asked if there's a private right of action under this constitutional amendment if it were passed, and I believe your answer was, or that answer of counsel that you brought up to the table was that there was a private right of action. Is that correct, that there is a private right of action for people to sue the state of Minnesota under this constitutional amendment if it's passed?
Representative Herr.
Madam Speaker, Representative Niska, yes, Minnesotans have a private right of action.
Representative Niska.
Thank you, Madam Speaker, and I have a follow-up question for the author, if she will yield.
She will yield. Representative Niska.
Thank you, Madam Speaker, and Representative Herr, what sorts of remedies then are available to individuals who do sue the state of Minnesota under the constitutional amendment that you are offering? Can they get an injunction against the state of Minnesota prohibiting or preventing the state from violating this constitutional amendment?
Representative Herr.
Madam Speaker, Representative Niska, so it's not that I'm not trying to answer your question, is that I would need to know. I mean, I actually really did look into this a lot. I talked to lawyers and civil rights lawyers and constitutional lawyers, and I asked them about the situation, and they said to me, well, you know, we really have to know who the state actor is, what the circumstances are, which one is the state actor? Is it the state itself? Is it a county? Because then, you know, it goes to a county attorney. So I really did try to figure out, but there is no simple answer for me just to tell you that this is what would happen with that. And so it's not that I'm not trying to answer your hypothetical, but that there's actually many, many steps in between depending on who the state actor is and where it's litigated. And so I don't know if you, like I said, I don't want to be sitting here trying to answer 100 hypotheticals about what particular situation at which level of the state actor. And so I hope that, you know, it's not that I don't want to answer, but that's the best I could give you. If you have a very specific thing, I'm sure that my colleague, Representative Dave Pinto, would probably be better at entertaining specific scenarios that you might have for him to answer.
Representative Niska.
Thank you, Madam Speaker, and actually that was quite a good answer, Representative Herr, which is pretty much everything's on the table, depending on the issue. And so the problem with this kind of a very, very sweeping amendment And in particular, we had a long discussion about the concern about the words in effect, discriminate in effect on the basis of any of one of these categories. Anything is on the table. And that is really, really, really concerning for our form of government. When you talk about a lawsuit that could be brought against the city, or like you suggested, a county or the state, on account of a claim that something that the state actor is doing would in effect discriminate on the basis of one of these categories. So there are lots of decisions that are made by the state, including decisions that are made regarding funding, that have potential arguments for disparate impact against the state. And so I think your answer is actually 100% correct, which is we don't know. Probably there would be remedies, injunctions against state actors that would involve a judge telling the state or telling Hennepin County or telling the city of Minneapolis or telling any host of government entities that, in fact, the decisions, the budget decisions made by their democratically elected representatives are not going to stand. So the budget decisions that we make on behalf of the people who elect us to this body are not going to stand under your constitutional amendment. I think that was your answer, and I think that is 100% correct, and that's exactly why we need this Perryman Amendment. There is a reason why in the Constitution it says, our current Constitution, which I think this is going to override or supersede, it says that spending decisions have to be made by the legislature. The reason our Constitution is set up that way is because we are a government of the people, by the people, for the people, not government of lawyers, by judges, for activist groups. That's what your amendment turns us into. It turns the state of Minnesota from a democracy into a state run by judges, into a state run by lawyers, into a state run by activist groups that bring lawsuits and get judges to order the state to change laws or to spend money in different ways than what the democratic process allows. So this is a fundamental change in the form of government in Minnesota, the underlying amendment, and that's why the Perryman Amendment is so important. So thank you for your clarity on that, Representative Herr. I hope the people of Minnesota are paying attention. You're being asked to give up democracy under the guise of equal rights, under the guise of non-discrimination. You're being asked to cede your power to hold your elected officials accountable for the spending decisions they make so that gender justice and other activist groups can go to the courts and get the courts to order the state of Minnesota or your county or your city to tax and spend in different ways than what you would agree to. That's what this amendment does, unless we adopt the Perryman Amendment. So that's the question before the body. Are you for democracy or not? Are you for democracy or not? If you're for democracy, you'll vote for this amendment.
Further discussion. Representative Perryman.
Thank you, Madam Chair. May I ask the author a question?
You may. She will yield. Representative Perryman.
Thank you, Madam Chair. Rep. Herr, I have a quick question. After Representative Harry Niska's talk, there is if we do have this instance happens and the mandate is a result of a claim, how will the state find funds to pay for the mandates caused by the ERA? Will it mean that taxes are raised for programs or something to pay for these kind of lawsuits if we do have some actions towards something that happens with the ERA?
Representative Herr.
Madam Speaker, Representative Perryman, so I just want to address what Representative Niska said first, that's already how law works right now. That's already how lawsuits happen right now. Nothing changes with how processes work when people challenge what is in our current Constitution versus what is in law right now. Nothing changes. So passing the ERA means everything stays the same. Representative Perryman, I'm not quite sure what your question is asking me. I don't know what you're meaning because, again, like we stated to my response to Representative Niska, it depends on who the state actor is, and so the state doesn't pay for everybody's lawsuits or every settlement. That's not the way it works right now.
Representative Perryman.
Thank you, Madam Chair. Thank you, Rep. Herr. Well, I would hope that, again, I think I always end my amendments with saying I'm putting my sales hat on again, and that I hope that you'll consider this and light up the board green because of democracy and what we need to get done, and just clarification. One little paragraph in it, and that we should be always adding clarity to anything we write so it's very clear. So thank you, and let's get a green board. Thank you.
The member from Olmsted, Representative Quam. Sorry, Representative Perryman, a couple of folks popped up during your closing argument. Representative Quam.
Thank you, Madam Speaker, and this is not the first amendment I've heard. Nothing changes. It's already law. Why are we doing this constitutional amendment if all the components are already there and nothing changes according to the author? I think our amendments are bringing up things that we need to clarify before doing a constitutional amendment, which is not trivial. And almost every argument we come up with, that's the way it already is, nothing changes. And people watching, that's not true.
The member from Hennepin, Representative Robbins.
Thank you, Madam Speaker. I'm sorry to speak again after Representative Perryman, but I just have heard the authors say over and over that it depends on who the state actor is. So if Representative Herr would yield to a question.
She will yield. Representative Robbins.
Thank you, Madam Speaker. So Representative Herr, I've had it written down multiple times from different sections of this debate that you keep saying it depends on who the state actor is. It changes that we have to define who the state actor is. So could you please tell us who constitutes a state actor under your amendment?
Representative Herr.
Madam Speaker, Representative Robbins, I'd like to direct you to lines 2.5 to 2.6. It talks about the purpose of this section. The state means the state or any agency or political subdivision of the state, and so that's where it's defined.
Representative Robbins, just a reminder, we're on the 825 amendment. Representative Robbins.
Thank you, Madam Speaker. Yes, but this does go to the 825 because who the state actor is depends on the use of public funds. And this is about, the amendment is about the expenditure of public funds. And we had a lengthy discussion, I don't know when, earlier in this debate about whether a state actor is a nonprofit, a church, a hospital, anyone who receives public funds. And the definition that Chair Herr read just now from the actual amendment, it's not clear. State means state or any agency or political subdivision of the state. So if you're receiving state funds, it could be construed that you're a state actor. And the testimony in the Rules Committee, Chair Herr did say if you got public funds, you would be captured under the state actor definition. And so this is critical to the Perryman Amendment members. If we do not have clear understanding of whether any group that gets public funds is considered a state actor, it will open the door to all these lawsuits of the church in your town that has a daycare center, the food banks, the hospitals, the groups that do such good work in our communities are all at risk, members. So we have to understand this definition. So Chair Herr, if Chair Herr would yield to one more question.
She will yield. Representative Robbins.
Thank you, Madam Chair. Thank you, Chair Herr. So if a daycare facility uses state dollars to pay for childcare, or if a medical facility takes Medicaid patients, would they be construed to be a state actor?
Representative Herr.
Madam Speaker, Representative Robbins, I'm going to remind us of the conversation we had earlier about this, is that receiving state, public dollars does not automatically make you a state actor.
Representative Robbins.
Thank you, Madam Speaker. And that is exactly the answer we had last time. It does not automatically make you one, but we tried earlier in earlier amendments to explicitly have an amendment saying if you receive state dollars, you are not a public actor. And clearly, you're saying it doesn't automatically make you one, but you certainly could be one. So members, we are opening up every group in this state to lawsuits under this constitutional amendment, which, if I have to remind everyone again, is at the highest level of scrutiny. The Perryman Amendment is essential for anyone who gets state dollars in our communities to be protected from the implications of this and shutting down very important work that's going on in all of our communities right now. Please vote green on the Perryman Amendment.
The clerk will take the roll on the amendment. Will the chief clerk please call the name of the member who's voting remotely?
Carol.
Carol, no.
Carol, no.
The clerk will close the roll. There being 63 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. Representative Long.
Madam Speaker, I move that Senate file number 37 be laid on the table.
Representative Long moves that Senate file 37 be laid on the table. All those in favor, please say aye.
Aye.
Those opposed, please say no. The motion prevails. The bill is laid on the table. Representative Long.
Madam Speaker, I move that the vote whereby the House adopted the Conference Committee report on House File 5242 be now reconsidered.
Representative Long, would you like to make a motion first to pull it off the table? Representative Long.
Yes, I would like to make that motion.
Representative Long moves to pull Conference Committee report House File 5242 from the table. All those in favor of the motion, please say aye.
Aye.
Those opposed, please say no. The motion prevails. Do you need? The clerk will report the bill.
House file number 5242 is amended by conference.
Representative Long.
Madam Speaker, now I move that the vote whereby the House adopted the Conference Committee report on House File 5242 be now reconsidered.
All those in discussion to the motion on reconsideration. The member from Morrison, Representative Schultz.
Thank you, Madam Speaker. Yes, this is a pretty big bill, very important to the citizens of Minnesota, and I think it is worthy of our reconsidering whether or not we would take action on this bill. I actually am of the belief that taking action on this bill would not be in the best interests of the taxpayers of the state of Minnesota, whether it's from the business regulations, the labor regulations, the burdens that this would be for Minnesotans. I would say that we should not take this up, and the citizens, especially considering we only have approximately 25-ish hours left in this legislature. There are a few other bills I would say would come as a higher priority, both to me and to the citizens of Minnesota when you consider some increased fees. And like I mentioned, a whole host of different regulations that are gonna make Minnesota more unaffordable for the people that we should not move to take this bill from the table. And frankly, I think that we don't need a vote on this bill tonight. Thank you, Madam Speaker.
Representative Long.
I agree. Let's reconsider it.
Representative Petersburg.
Thank you, Madam Speaker. And to, if Mr., Chair Hornstein would rise for a question.
He will. Representative Petersburg.
Thank you. Now, I was on the conference committee, and we had finished all the work. The Senate agreed and closed it all up. Do you have a reason for opening this back up? Do you have any information as to why we should do that?
Representative Long. Representative Hornstein. Representative Hornstein will yield to Representative Petersburg, who has the floor. Representative Hornstein.
My understanding is that there's an additional issue that needs to be considered.
Representative Petersburg.
Thank you, Madam Speaker. Well, maybe it should be Representative Long that I should ask as to why we are opening up this conference committee that has been closed, and Senate is already working on other things. Why we would be opening it up.
Representative Long.
Thank you, Madam Speaker. Yes, we are reopening the conference report so that we can include the agreement that we made tonight with Uber and Lyft. This is appropriate for the Transportation Conference Committee.
Representative Petersburg.
Thank you. I'm surprised because I thought this was something that had been agreed to and would be a standalone bill for Uber and Lyft rather than putting it into a conference committee that we already closed. So I'm not real crazy about opening it up. If it's something that is an agreement by the DFL leadership, then I think they ought to just pass it and put it in a bill by themselves. So I would recommend not reopening it and not reconsidering.
Representative Nash.
Thank you, Madam Speaker. I guess I'll ask the Majority Leader to yield to a question since this is his motion. Could you tell us, Majority Leader Long, when we'll see the conference committee posted so that the public can come and observe the deliberations and perhaps the proposed language, since I'm sure all of our members and yours would probably like to be able to see that as well as the public?
Representative Long.
Thank you, Representative Nash. I'm sure that the chairs of the conference committee will be posting the meeting notice ahead of time, and that we will also be posting the language ahead of time when it is available with plenty of time for review.
Representative Nash.
Thank you, Madam Speaker. And Representative Long, if you'll continue to yield.
He will yield for another question. Representative Nash.
Thank you. And I'd just like to be able to confirm that the language is in hand and that our members will be able to see it, because I believe that we'll be continuing this deliberation. We'll be seeing this on the floor, if you're going to be adding it into the bill, and when do we have an expectation of when this will actually be posted and gavelled in for the conference committee?
Representative Long.
I do not have that information at the moment, Representative Nash, but I can assure you that the conference committee will be held with full public review, and that we will have the ability to review the language ahead of time.
Representative Nash.
Thank you, Madam Speaker. And are there going to be sufficient notifications and times for amendments and public testimony, and just making sure that, just like every other conference committee that I've been on and that we've all been on, that we have that opportunity for those people to take full advantage of what they, as the public, should expect?
Representative Long.
There absolutely will be opportunity for public review.
Representative Nash.
Well, that news makes my heart soar like a hawk, Madam Speaker. I just want to make sure that we get that posted and that we have that, so that we're not trying to rush through things here, and it's getting close to the dark of night. I think we're going to be arriving there soon, and I just want to make sure that we do know where that's going to be. Is it going to be here in the Capitol? Is it going to be in 120? I mean, just give us a couple of guidelines, if you could.
Are you asking him to yield again?
I am asking him to yield, yes, Madam Speaker.
Representative Long.
Madam Speaker, I don't chair the conference committee, nor do I control room assignments, but I am sure that there will be posting with ample time for folks to find the room.
Representative Nash.
Thank you, Madam Speaker. Well, I'll ask Chair Hornstein to yield, if he would.
He will yield. Representative Nash.
Thank you, Madam Speaker. Chair Hornstein, you and I have a great relationship, and I respect you tremendously. Can you guarantee that we will make sufficient announcements and make sure that the public has ample time to perhaps get here, since it's a tad on the late side, and want to make sure that those folks who are deeply interested in this, because there are many, many people who are very concerned by this, want to make sure that they have ample time to do that. So could you tell us when approximately you're looking at composing this conference committee?
Representative Hornstein.
Thank you, Madam Speaker. Representative Nash, I will be in contact with those who are finalizing the language, and it has been our tradition in this conference committee that we give ample notice and allow for public scrutiny.
Thank you, Madam Speaker.
Representative Nash. The member from Stearns, Representative Demuth.
Thank you, Madam Speaker. And would the Majority Leader yield for a question?
He will. Representative Demuth.
Thank you. Mr. Majority Leader, I just want to have an assurance, as there's going to be provisions that are actually put into the conference committee and then making its way back. Two questions. The first is, will we have ample time to fully look at that and debate the bill as it comes back with a new provision?
Representative Long.
Yes.
Okay.
Representative Demuth.
Thank you, Madam Speaker. And if he would yield for another question.
Representative Long will yield. Representative Demuth.
Thank you, Madam Speaker. Majority Leader Long, I just want to make sure that what is being put into this conference committee report will be germane as it relates to Rule 6.40. And I'm just going to read a portion of this for the body. This is where my question is coming up. It says a conference committee report must include only subject matter contained in the House or Senate versions of the bill, for which that conference committee was appointed, or like subject matter contained in a bill passed by the House or Senate. The member presenting the conference committee report to the House must disclose all substantive changes to the House version of the bill. So my question is, Mr. Majority Leader, will this be germane according to 6.40?
Representative Long.
Yes.
Representative Demuth.
Okay, thank you, Mr. Majority Leader, and I understand this is being put in this. Is there a possible consideration of having this as a standalone so we don't end up running into a problem that could question the germaneness?
Representative Long.
Thank you, Madam Speaker. Thank you, Leader Demuth. We are very late in session and running very short on time, so we are trying to make sure we can get all our work done.
Representative Demuth.
Thank you, Madam Speaker. And then for the body, I understand we are running short of time, but I would hate for this to come through and it would be not germane and there would be a problem. As we complete the questions or our debate a little bit on this motion, Madam Speaker, I would request a roll call.
Representative Demuth requests a roll call. Seeing 15 hands, there will be a roll call. Further discussion. The member from Stearns, Representative O'Driscoll.
Thank you, Madam Speaker. And given the discussion on the topic this evening, I will remind the body that there are other mechanisms within our control and our rules to be able to expedite this. We have on a number of occasions major pieces of legislation, some of them having to do with agriculture, some of them having to do with other appropriations, with weather-related damage and the like, to bring that as an urgency to the floor, amend the language, send it over to the other body, and get a concurrence on that so that we do not end up taking what I'm hearing is precious time that the Democrats feel they still need in order to be able to complete their agenda for the 2024 session. So there is a very quick and fast way to be able to do this and to keep a promise on having this as a standalone bill. So I strongly encourage a support of denying or, on the motion to reconsider, to vote no on that and use the other tools that we have here in this body to be able to expedite those very important, apparently, developments from earlier this evening. Thank you, Madam Speaker and members.
Discussion. The member from Douglas, Representative Franson.
Thank you, Madam Speaker. Members, I think we have a lot of work to do left. I know that the Human Service Policy Bill has to be done yet, State Gov, and I believe taxes. And I know that the Senate is extremely far behind on our bills. Oh, yes, okay, so we still have here in the House members, we have EMS, we have scope of practice, which is not closed, but taxes. We have Queer Panic. We have ERA that we're still debating. We have HHR, the historical horse racing. We have a corrections bill. Plus, we still have a bonding bill to get done. And members, I am going to correct the record. Representative Schultz, we have about 12 and a half hours, actually, not 12 and a half. It is 11 hours and 29 minutes. 11, did I say 11? Oh my gosh, I mean 23 hours and 29 minutes to go. Now the Senate has taken an extremely long break yesterday and the majority of the day today. For whatever reason, I will not elaborate on what my thought process is on that quite yet, but that is not our problem. It is not the Republicans' problem that you, the majority, who has the entire government, that is not our problem that you don't know how to manage your schedule. This bill, this Uber Lyft bill, needs to go through the proper channels. We have zero public testimony, we will have zero thorough public testimony. It is doubtful whether or not Uber Lyft will be able to have customer or testimony from people who use Uber Lyft about how much this is going to raise costs for individuals who use that as transportation. And members, it is our job to make sure that this gets done correctly. Again, this is not our issue. This is a Minneapolis issue. They caused the problem. We have been wanting to work with you for months, actually, on this issue. We have said, hey, come work with the Republicans. You chose not to, and now we have 29 hours and 27 minutes left. 23 hours and 27 minutes left. I don't want to be here any longer. So 23 hours, 27 minutes left.
The member,
and we have a lot of work to go. We have a lot of work to go. So members, I am going to stand with Representative O'Driscoll. I think we need to have a public, thorough vetting of that. Thank you, Representative O'Driscoll. I will not be supporting the motion to re-refer. Thank you.
the member from Brown, Representative Torkelson.
Well, thank you, Madam Speaker. If the Majority Leader would yield for a question.
He will yield. Representative Torkelson.
Representative Long, it seems like we have a simple approach to this. We have House File 4746, which is an Uber Lyft regulation bill. Why wouldn't we do the simple thing and use that bill to get this moving quickly and cleanly without any challenging the rules to get this very odd process done that you have proposed?
Representative Torkelson, I am guessing you asked him to yield, and he's looking like he's going to yield.
I thought I did ask him to yield.
Okay, I was just a little step behind up here. He will yield. Representative Long.
Thank you, Madam Speaker. Thank you for the question, Representative Torkelson. We've determined this is the quickest way to work this out with the Senate and to get this bill done, and we want to use each of our 38 hours and 212 minutes that we have remaining to get this done.
Representative Torkelson.
Well, thank you, Madam Speaker. Thank you, Representative Long. I refuse to do math in public. It's dangerous. But I really fail to understand the logic here, Madam Speaker, Representative Long. This, you're challenging the rules. You're stretching the rules to force this into a bill that's already been approved. And you're going to open that bill back up in a way that is not appropriate because it's not part of that original bill. You're challenging the rules, you're forcing it in, and you've got a bill right here where you could run this alone and do it cleanly and quickly. There's something mysterious going on here that, I don't understand math in public. I also don't understand exactly what you're trying to do here. Representative Long, if you would yield for that question, Madam Speaker.
He will yield. Representative Long.
I think I was pretty clear what we're trying to do. We're trying to make sure that we have a statewide rate passed for Uber and Lyft drivers to make sure that they get fair compensation.
Representative Torkelson.
Well, Madam Speaker, you didn't answer my question. I don't understand why you wouldn't run this as a separate bill when you have that opportunity. That seems like the cleaner, quicker way to do it. We're going to have probably a long rules fight on this if you proceed in the way you are proceeding. If you would yield for that question, Madam Speaker.
Representative Long.
Thank you, Representative Torkelson. As I said before, we are taking this path because we've determined with the Senate that this is the most expeditious way to get this done.
Somebody bring them a calculator. Representative Long.
Thank you, Madam Speaker. So we had a good colloquy, and I think we are going to amend our plan, and we are going to continue to open up the conference committee. But we are before we bring the bill back, we will make sure that we bring as a standalone the language, and so that we can establish a House position and pass it off the House floor.
Representative Torkelson.
Thank you, Madam Speaker. Thank you, Representative Long.
Further discussion on the motion for reconsideration. Representative O'Driscoll.
Thank you, Madam Speaker. Members, just for the record, we spent about 12 to 14 minutes discussing what would have taken us about 7 minutes to do procedurally. So we've lost 7 of those 38 hours and 242 minutes that the Majority Leader was speaking about earlier.
The clerk will take the roll on the motion for reconsideration. Will the clerk please call the name of the member voting remotely?
Carol.
Go ahead.
Carol, yes.
Carol, aye.
The clerk will close the roll. There being 72 ayes and 52 nays, the motion prevails. The bill is before us. Representative Long.
Madam Speaker, I move that House File 5242 be returned to the Conference Committee.
Representative Long moves that House File 5242 be returned to the Conference Committee. All those in favor, please say aye. Those opposed, please say no. The motion prevails. The bill will be returned to conference. Representative Long.
Madam Speaker, I move that Senate File 37 be taken from the table.
Representative Long moves that Senate File 37 be taken from the table. All those in favor, please say aye. Those opposed, please say no. The motion prevails. The bill is taken from the table. The clerk will report the bill.
Senate File number 37, an act proposing an amendment to the Minnesota State Constitution, Article 1.
There is an amendment at the desk. The clerk will report the amendment.
Rarick moves to amend Senate File number 37, the unofficial engrossment. The amendment is coded A12.
The member from Wright, Representative Rarick.
Thank you, Madam Speaker. Before I get going on this amendment, I'd like to ask for a roll call.
Representative Rarick requests a roll call. Seeing 15 hands, there will be a roll call. Representative Rarick.
Thank you, Madam Speaker. It's getting very late, and I didn't want to forget. So, members, this bill came only through the Rules Committee for a hearing. That's it. Nothing else. In the Senate, it had many other stops. Here, one. And it was really stunning to me when we did have the hearing in Rules Committee, which we don't have many. It's not very often. But there was something that came up in the testimony from the public that was rather jarring. And my amendment addresses some of that concern. And as you read the language of the bill, Madam Speaker, can you quiet the chamber?
Members, please take your conversations off of the House floor into the retiring room or the alcoves, deeper in the alcoves. Representative Rarick.
Thank you, Madam Speaker. It's late. It's hard to hear myself think. Okay, so this amendment, as you read it, and it's just a 2-page bill to put a constitutional amendment on the ballot. It's not even 2 full pages. What's interesting to me is the language that goes before the people, the language that goes on the ballot. It's very short. I'm just going to go ahead and read it so we can all be on the same page. It's on page 2 if you want to follow along. Shall the Minnesota Constitution be amended to say that all persons shall be guaranteed equal rights under the laws of the state and shall not be discriminated against on account of race, color, national origin, ancestry, disability, sex, including pregnancy, gender, and sexual orientation. Now, I don't even remember exactly when we started the debate on this bill because it has been days. It's been days that we've been debating this. And we've debated many of the words that are on the paper that I just read. The 2 words we have not debated very much, almost none, is including pregnancy. Now, it seems rather innocuous, including pregnancy. And someone that was unaware of what that actually means might think, well, of course we don't want to discriminate against someone that's pregnant. The cute little grandma that goes to the poll, and there's lots of little grandmas and lots of little grandpas that go. Someone that isn't completely aware of what this language does will look at that and say, yeah, we don't want to discriminate against someone that is pregnant. But the fact of the matter is, it has very little to do with discriminating against someone who's pregnant. Because when you flip the page over, what goes into our state constitution is the words, making and effectuating decisions about all matters relating to one's own pregnancy, or decision whether to become or remain pregnant. And even in that, it doesn't use the word abortion. And so the language of the bill will enshrine abortion in our state constitution up until the moment of birth. It is the most extreme abortion laws in the entire United States and on par with some of the most extreme nations in the world. And we are enshrining this in our state constitution, the highest law of our land in Minnesota. The U.S. Constitution trumps that, but the highest law here in Minnesota. And we don't even use the word abortion. We don't even use the word. It's not in the bill. It's not in the language that goes before the people. And let me tell you what they had to say about this in the one and only committee that we had, the one and only hearing that we had in the House of Representatives, the only public vetting we had of this in the House of Representatives, and this is what some of the people had to say. Mohammed Ahmed said this: "We believe in democracy. We believe in democracy. And this will enshrine death culture. This will enshrine death culture in our Constitution. Don't fool the people." It's Mohammed Ahmed is who said that. Don't fool the people. This is enshrining the death culture in our very own Constitution. Another woman said, you need to actually include the word abortion in the language in front of the people. Of course you do. And yet here we are. In my amendment, it adds some of the language that will go into the Constitution on the ballot. It adds decision whether to become pregnant, whether to become or remain pregnant. Now, I would have liked language that went even farther, to actually include the word abortion. Now, this is what goes before the people is vague. And there's even, people have used words like deceptive. I'm not using that word, but that is what many people have said. It lacks transparency. So there was a college student that came, Ms. Falls from Minneapolis. And she said, this lacks transparency and it's deceptive. Young college student. She had to be, 20, 21 years, maybe even 19. She was young. She was under 20. And she said, I want everyone that looks at this language on the ballot to know what they're voting for. Because right now they don't. And in fact, this was actually when this language was discussed on at issue. I'm kind of an at issue fan. And Amber Reichgott Young was talking. Now, she was a senator here, right? Some of us, not me, but some have served with her that are still in this body. And Tom Hauser asked her, well, it doesn't use the word abortion. How are people going to know that that's what they're voting for? And instead of pointing to the language that is before us in this bill, her answer was this: well, there's going to be millions of dollars spent. I'm sure the public will know after all that money is spent. What a sad tragedy. We're not doing our job here at the legislature if we have to depend on outside organizations to inform the people what we're doing. What are we doing? We're not even using the word abortion, and we are enshrining the most vile, divisive, difficult, and radical abortion laws in the entire United States in our state constitution without even uttering the word. I knew that this was going to be a really difficult many days as we debated this. And we've heard some very difficult stories from particularly the women on this side of the aisle and a few from that. And I'm not going to go into the story of why I am unapologetically pro-life. I'm not going to go there. I have shared it before, but tonight is not the night. I'll just say this. When you've held your own baby in your hands and she takes her last breath, it changes a person. So members, like I said, I would like to have an amendment that went farther and actually included the word abortion, that goes before the voters. And if you want to add other words, go right ahead. In vitro fertilization and all these other things that we're probably going to be enshrining in our state constitution as well, because it says all matters regarding pregnancy or to become pregnant. So the state might be responsible for all kinds of costs. But unfortunately, the only committee that this bill went through is the Rules Committee. We didn't go to a Health Committee. We didn't go to Ways and Means. We went to the Rules Committee and then here. So I guess we're going to have that conversation here on this floor. Members, I would ask for your support on this amendment. And I know I've got several members that really want to speak to this because this is one of the most difficult things of what's in front of us. We are putting two completely different things on the ballot and just putting it all together. Abortion should not be put together with the ERA amendment. And you know how many people think that? About 68% of Minnesotans that were polled by KTSP. Channel 5, I'm very tired. The KSTP poll said 68% don't want it that way. They want some limitations, and they don't want those two to be together on the ballot. So members, I ask you for your support for this amendment.
Representative Long.
Thank you, Madam Speaker. So this amendment.
I was thinking you were going to talk about midnight.
Oh, sure. Be happy to. Madam Speaker, the hour is late. I am getting tired, but I would like to keep going, and I move that we waive Rule 1.5 and let us meet past midnight.
Representative Long moves to waive Rule 1.5 to allow the House to meet past midnight. All those in favor, please say aye. Those opposed, please say no. The motion prevails. Discussion to the Rarick A12 amendment. The member from Ramsey, Representative Hurt.
Madam Speaker, Representative Rarick, I just want to address really quick. I know that we've had a lot of conversation around that this was only heard in rules, and I want to be clear that this bill, that is the place that constitutional amendments are heard is in rules, and we did have a lengthy hearing in rules, and so that was the proper committee in which to hear this bill. I want to just state that the purpose of a ballot question is to summarize the constitutional language, and that is what the ballot question does. Pregnancy is more encompassing. It is not just about the decision to become pregnant or remain pregnant. It is also includes miscarriage care, postpartum care, lactation, just to name a few. So keeping the ballot questions just as it is in the underlying bill is actually more accurate, and so I recommend a no vote.
Discussion. The member from Anoka, Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Rarick, for this amendment. And Representative Herr, as you noted, there is a legal standard that goes into whether or not a ballot question is proper in Minnesota. And that legal standard has been litigated many, many times. And it's quite likely to be litigated again this year. And so I do have a question about that if Representative Herr will yield.
She will yield. Representative Niska.
Thank you, Madam Speaker. Representative Herr, was there a fiscal note on this bill related to the potential for litigation against the state of Minnesota related to the ballot question?
Representative Herr.
Madam Speaker, Representative Scott, there is no actual fiscal note to this, and we actually, in none of the bills that we passed, put a fiscal note on based on the fact that we think it might get litigated because any bill we pass off of this floor could be litigated.
Representative Niska.
Thank you, Representative Herr. That's not correct. We frequently have fiscal notes on bills. We had several bills last year in which there were potential litigation risks to the state, in which we did have fiscal notes. And so it's pretty stunning that there was no discussion, no questioning, no request from the budget office about what the cost will be. But there will be a cost to the state because there will be litigation against the state. Litigation against the Secretary of State, probably defended by the Attorney General's office about this question. And Representative Varick is 100% correct. This is very, very poor, deceptive ballot language to tell the people of Minnesota that we're just about pregnancy discrimination when in fact it's much, much broader than that. It covers, I think as the testimony, as the advocacy has been, it clearly is meant to cover issues related to abortion, codifying into Minnesota law, the most extreme pro-abortion policy in the country, probably the most extreme abortion policy in the world, covers many, many other issues. I know that we're going to get into some of those issues further in this debate related to surrogacy, related to treatments for infertility. Just on the previous amendment, we I think, established that it's going to cover potentially spending decisions by the state in order to help with potential reproduction. We've had many bills come through this legislature this year about state spending or insurance company spending on things like infertility treatments. The idea that just having the word pregnancy on the ballot gives the people of Minnesota any idea about any of that stuff is frankly absurd. And so I do appreciate, Representative Herr, that in the hearing you took exception to the idea that you were trying to be deceptive. I don't think anyone is questioning your motives, at least not your motives personally. But the fact of the matter is this amendment is being brought to the ballot in a way that is not going to explain to the people of Minnesota what's truly going on. So, Representative Varick, thank you for this amendment. It's very important, and I'm sure we'll have some further discussion about what actually is happening under this amendment and what the people of Minnesota should be told about it, but I urge members to vote yes.
The member from Goodhue, Representative Altenurf.
Thank you, Madam Speaker, and thank you, members. Thank you, Representative Varick, for bringing this. This is a very, very simple ask, okay? We want to make sure that when we're asking a question on the ballot, that it is very clear, and I think it is our duty to make it clear. That's what we're doing right here in this body. So my concern is right now in Minnesota, we do have a lot of citizens that English might not be their first language. English might be their second language. We have a large Muslim community, Hispanic, Latinos, and all of these communities typically are also very against abortion. And if the ballot is simply saying pregnancy, how does that translate in these other languages? How does that translate so they understand truly what they're voting for? This is not clear, members. This is not clear, and it's really not fair that we're doing this. As mentioned before, the KSTP poll, 64% 64% of Minnesotans are asking that this question be two separate questions, one for the ERA and then one for the pregnancy or, quote, abortion part of it. So members, this is simple. We need to make sure that we're clear in what we're asking. In fact, I know when I've been in committee hearings, I have heard the majority party in instances say that we need to have plain language. I've heard those words, that we are in some instances saying that we have to have plain language so it's crystal clear, and yet something that is this important, we are now very vague. We are not actually telling the public, we're not telling Minnesotans what they're actually voting for, which is enshrining into our state law, into our Constitution, the most extreme, the most radical abortion laws in the country. Last year in 2023, you came out right out of the bat, number one priority, HF1, abortion to birth. That was your number one priority, folks. We all know it. You came out with it. We were voting on that in January. Now, by putting this into our state constitution, you owe it to Minnesotans to be crystal clear on what they're voting for. This is not right. This is not right, and the hypocrisy is thick. When sometimes you say that we need to use plain language, sometimes in committees you say we need to be crystal clear for our English second learners. Sometimes that's what you're saying. And now this is so vague that people of faith communities, of Muslim groups, of Hispanic groups, would potentially be voting for something that they don't understand what those words mean. Members, we are asking for a very simple fix. And in fact, this is quite deceptive to the Minnesota public for us to not make this change. I know, Representative Herr, you said you wanted to use the word pregnancy because that was all inclusive. Then add the word abortion. Add the word. You cannot say in committees at one point that we need to use plain language, and in something that is this important, to now ignore plain language. Members, please support the RAREX amendment. Please support this. And let's be crystal clear with Minnesota. You know, a lot of people don't like politics, and this is why. This is why, right here, members, people don't like politics because this is a sham. This is hiding behind the words. And we owe it to Minnesotans to be crystal clear on something this important that they're voting for, especially when we have faith communities that speak different languages that do not understand these words. This is very manipulative, it's very deceptive, and quite frankly, it's very disgusting. Be clear in your words, use plain language. This is not a difficult ask. This is not a difficult ask. Be clear in your words for Minnesota.
The member from Carver, Representative Nash.
Thank you, Madam Speaker. Would the author of the underlying bill yield to a question?
She will yield. Representative Nash.
Thank you, Madam Speaker. Representative Hurd, I want to make sure that I heard you correctly because it's late and we're all very tired, but did you say that the Rules Committee is where constitutional amendments are heard?
Representative Herr.
Madam Speaker, Representative Nash, yes.
Representative Nash.
Thank you, Madam Speaker. Representative Herr, if she would continue to yield.
She will yield for another question. Representative Nash.
Thank you, Madam Speaker. Representative Herr, are you familiar with House File 4598? It is Representative Long's constitutional amendment for Re-elections Commission, and I believe he called it Good Government Bill.
Representative Herr.
Madam Speaker, Representative Nash, I am familiar with it, but I think maybe you might want to ask Representative Long about those questions.
Representative Nash.
Thank you,
I'm
Madam
sure
Speaker.
you're going to relate this to the 812 any second now.
We're getting there, Madam Speaker. You know that I'm more than capable of doing this. So, well, Representative Herr, I'm going to remind you that this was heard, the Majority Leader's bill, House File 4598, was introduced on and then referred on 3.7 to elections. And then on 3.18, it was in state and local government, where you serve on that committee. We were in the committee that day. So we heard the constitutional amendment in state government finance, and I have to think ostensibly it was also heard in elections finance committee, and then it made it to rules. So your supposition that constitutional amendments are only heard in the rules committee is wrong, because you participated in the debate relative to Representative Long's good governance elections bill. So I just wanted to set the record straight that, once again, this was not a properly vetted bill, not properly pathed bill. We heard it in rules. It was very brief, and there are 16 members in rules, only 16 members. And I'm just wondering why was that skipped? Why was this particular language? And there was a version of ERA that was heard, but it's not this language. This particular language was never heard in state government finance. If she would yield to a question and affirm that.
She will yield. Representative Herr.
Madam Speaker, Representative Nash, and thank you for bringing that up, because I do just want to clarify that Representative Long's bill, House File 173, was heard in March of 2023. It was amended and then heard in rules. Same thing with this bill. This bill was actually heard in State Gov last year, and then it was amended, and then it got heard in rules. Same path, same process, same situation.
Representative Nash.
Thank you, Madam Speaker. Well, let's be very clear. Representative Herr just said a bill was heard and then amended and then heard in rules. So the language in this particular bill were not heard in anything other than rules. Once again, we're trying to hide things by saying, well, a version of this, a thing that says ERA on it, printed on paper, was delivered to a committee and then
Point of order,
done
Madam
so.
Speaker.
Representative Herr, please state your point of order.
Representative Nash is impugning my motives. He's saying that I was trying to hide something in the process. The process was very transparent. It actually went to the committee, was amended, and then heard in rules, just as the bill that Representative Nash is referencing. It was amended after leaving State Gov, and then it was heard in its final form in rules.
The point of order on motives is appropriate to interrupt the speech for, and Representative Nash, if you can just say words that express your meaning but don't impugn motives, that'd be great.
Well, Madam Speaker, I never impugned motives. I merely pointed out that the exact language of this bill were never heard in state government.
That's okay to say, but saying tried to hide.
Morphologically, they are two completely different bills.
Representative Nash.
Thank you, Madam Speaker. The language on the two bills, morphologically, is completely different. So, add that to your lexicon there, guys, morphologically. So, once again, I'm just pointing out that it is a vastly different bill. I'll share it. I'll text you. It is a vastly different bill. It has not the same exact language, and as a result of that, it cannot be claimed that this bill, in its current format, was heard in anything other than rules. Thank you, Madam Speaker.
I have on the list, but I'm sure I'm missing somebody, Dotseth, Hudson, and Scott. So, yes, Bennett, you were before some of these people. The member from Freeborn, Representative Bennett.
Thank you, Madam Speaker. Appreciate it. Members, the language that's in this underlying bill, the ballot language, in regards to pregnancy, is a Trojan horse. And Representative Rarick, thank you for this amendment, because people deserve pregnancy. People, okay. Let's start that over again. I'm really tired. Yes, we deserve pregnancy. No, all right, I'm gonna start over. Oh my goodness, okay. This language is a Trojan horse in that it uses pregnancy when it really means abortion. And the people of this state deserve more. They deserve to know what they're voting on and what it really means. Everybody deserves transparency. And you know who especially deserves this transparency? The persons in this state that have no equal rights. And we've been talking about a lot of equal rights tonight. And I'm talking right now about the child in the womb. I think of baby Everett, Representative Engen's little boy. He was born, a little over 6 weeks ago, I believe. Baby Everett right now in the hospital, growing, or praying that he's continuing to grow strongly, has all the equal rights that we all have. But a little over 6 weeks ago, he didn't have any rights, and especially the most precious right to life. So that baby and those babies in the womb deserve the transparency in this language that allows the people of Minnesota to know exactly what they're voting for. And that when the word pregnancy comes up, it's really talking about abortion and other things. But as the bill author stated, pregnancy means a lot of things in this bill. And people deserve to know that they're talking about abortion. And the most extreme abortion laws enshrined into our Constitution, if this were to be voted through, more extreme even in the United States, but in the world. So it blows my mind that as a society, we will protect eagle's eggs, an eagle embryo that will hatch out and become an eaglet, and we know it's going to be an eagle, or we will protect turtle's eggs. That's an embryo that grows up and hatches into a hatchling, I learned. And yet, the one who deserves the most transparency in this language doesn't get any rights. You know, when I taught first grade for those many years, that's 6- and 7-year-olds, and I would look into their eyes, and I would see all their excitement and their imagination and their exuberance for life, and I would think, which one of you would not want to be here? And you know what? They all would want to be here. They all deserve those equal rights, even when they were in the womb. So for all those babies in the womb now, all those babies who will be in the womb in the future, let's give them the transparency they deserve. Let's give Minnesotans the transparency they deserve so that they know exactly what they're voting for. And that is to enshrine in our Constitution the most extreme abortion laws in the world. Thank you, Madam Speaker.
The member from Carlton, Representative Dotseth.
Thank you, Madam Chair, members. You know, one thing I've learned is the power of words. Thank you, Representative Rarick, for clarification of the power of words. Where I come from, our word is our word. Our word is good, and it's clear of what we stand and where we stand for. I, too, am unapologetically pro-life. You know, as a father's perspective, I'm blessed to be a father, a husband, and a grandfather. I go back to 1998. Found out that my wife was pregnant. And after a prior situation where she had a miscarriage. The prior child. You know, it doesn't just affect the mother, it affects the father as well. It's a traumatic thing that happens to you. But 1998, she was pregnant. Found out that early on that it was going to be a situation where they encouraged to actually terminate the life of the baby. We chose to do what it took to keep that baby alive. My wife was on bed rest for majority of the pregnancy. January 22nd, 1999, my baby girl was born. If we would have made that decision, she wouldn't be here today. Married. She just raided my freezer, deep freeze yesterday. So it, you know, the things your father, as a father, you care about your kids. In the last 3 years, I've seen a lot of smoke and mirrors in our state, in our nation. But what I've witnessed here in the last year and a half, 2 years at the Capitol, it's unbelievable. Your word needs to be your word. It needs to be good. It needs to be clear. You know, we're speaking of this ERA. This isn't my grandmother's ERA. This is a whole different bill. You know, we spoke of the days of Hubert Humphrey, and those times I actually once passed out literature for Hubert Humphrey. Yeah, a Republican passed out literature for Hubert Humphrey. It's a whole different scenario now in the state of Minnesota. At a time where we're seeing extreme abortions all the way to birth, rights of our elderly at stake, how come no one's talking about this bill affects our elderly as well? I got a 92-year-old Korean War veteran father-in-law. I just was at the other day when we actually had a break from recess here. He's got value. He's still living in his own home, on his own. You know, he's getting a little more frail. And we're currently considering actually moving him up to our home. But at that same thing, you still got to look at, he still deserves the dignity. He served our country, fought for our country. We need to preserve and protect those lives. The most vulnerable. I mean, that's at stake right now, too. There's a lot more to this ERA bill than what people are looking into it as. It's not the same bill that some of these people up top thought that they fought for years ago. I just pray that we come back to a moral compass in our state, and just pray that the fear of God comes back upon each and every one of us, and look at the consequences of what we're passing here. You know, the members across the other side of the aisle, a lot of us disagree on different items, but you know what? I still love you. I don't look at you as an enemy, but we may have different views and perspectives, but just don't try pushing this stuff on my family. What you do with your life, I don't care. But just don't have it where it's going to affect my kids, my grandkids, my father-in-law. That's all I ask. That's what I was elected to do, is to protect and preserve and protect those people. At the end of the day, I'll just close in this. I just ask that you come to a heartfelt decision on what you're doing. You know, I understand that you believe you're doing what is right. There's a lot more to this, and there's a lot more consequences with what we're doing. I ask you to vote yes for this amendment and put some guardrails in place that we need, and vote no on this bill. Thank you.
The member from Wright, Representative Hudson.
Thank you, Madam Speaker. Members, I'll recall your attention to just a few days ago, although at this point it feels like it could have been a couple of weeks. We spent several hours on this floor talking about cheeseburgers, as I recall. And the item under consideration was deceptive trade practices, false advertising. It's really super duper important that when someone makes the decision to purchase a hamburger, that they know exactly what it is that they're getting and exactly what value they're exchanging in return. Because we certainly wouldn't want somebody to think, going in, looking at a sign on the side of a storefront, that something marked as $12.99 was actually going to end up costing them $14, $15, a couple bucks more. Really super duper important to make sure that things are advertised just right. I'd like to appeal to that idea, that concept. Only in this case, the transaction that we're talking about is, do you want to fundamentally transform your government? Stakes are a little higher. And certainly if it's important to know exactly to the penny how much I'm going to pay for a cheeseburger, it's probably important to know exactly what it is that I'm going to get if I vote for this amendment on the ballot. And as it currently stands, I mean, right now, this amendment, we're focused on these two words, including pregnancy, but this whole thing could use a rewrite. I mean, I don't want to give a third reading speech here over an amendment, but just to tick down the items, maybe we'll put it in context first. So again, the ballot question reads, shall the Minnesota Constitution be amended to say that all persons shall be guaranteed equal rights under the laws of the state and shall not be discriminated against on account of race, color, national origin, ancestry, disability, or sex, including pregnancy, real quick there, including pregnancy, gender, and sexual orientation. Now, I would argue, and I think a lot of folks would argue, that when you take a look at the actual impact of what the underlying proposed amendment to our state constitution does, that doesn't come close to describing it. You're talking about an amendment that is going to erase the category of women as such in law. We had ample conversation about that last night. You're talking about an amendment that, I've been learning as I've been listening to Representative Niska talk through the legal implications, that's going to effectively take away democratic representation in a couple of different ways. It's going to turn the jurisprudence of our state, the policy setting, the rulemaking, the lawmaking, the legislating of our state over to lawyers, judges, activists, whoever can cough up enough money for the lawyers. It's going to encroach upon our religious liberty. It's going to cancel our freedom of conscience. Article 1, Section 16 of the Constitution will be completely meaningless after this thing passes. And of course, the question at hand. And this is the first time I've had to really put a point on it, a fine point on it in this chamber, in this setting, but I just want to be really super clear about what we're talking about here. The effect of this amendment, if ratified, is going to be for, I believe, the first time in the history of the state, to change our founding document, our highest law of the land, for the purpose of stripping civil rights from an entire category of human beings in perpetuity. That's what it does. It says that if Everett Ingen, who even to this date was born at 28 weeks, it's been 45 days, he hasn't hit that 40-week threshold that's generally considered to be full term, but nobody, not a single person, there's not anyone who denies that that's a human child. But if he had a change of address, if he was still in the womb, the exact same human being, exact same characteristics, same nature, he would be eligible for termination. And by the way, that's under current state law. See, what I'm describing here, you've already done. You've done it in statute. This isn't something that is going to happen if this is ratified. This is something that you've already done in statute. If this is ratified, it just makes it permanent. We've already stripped civil rights from an entire category of human beings in this chamber. which is a remarkable thing to consider an accomplishment. And now we're considering making that permanent, for perpetuity, for all time. We're going to look at an entire class of human people and say, we are not even going to acknowledge your existence. And we're going to allow anything to happen to you with no regard for your inherent value. I think that might deserve a little bit more than including pregnancy in the ballot question. And we're not offering, some dissertation. The replacement phrase would be the decision to become or remain pregnant. Just adding a little bit more specificity on what it is that we're talking about, so that people know when they go to the ballot that they are voting to permanently strip civil rights from the unborn up until the very moment of their birth. I think that is advertising that should not be false. Thank you, Madam Speaker.
The member from Anoka, Representative Scott.
Thank you, Madam Speaker. Would the author of the bill yield for a question?
She will yield. Representative Scott.
Thank you, Madam Speaker. Representative Herr, you ran through a list just a little bit ago of the what pregnancy under this law or this proposed constitutional amendment could mean. I think you said like miscarriage care, there were some other things. And I just wondered if you could go through that list again if you have it written down.
Representative Herr.
Madam Speaker, Representative Scott, I listed just a few of what pregnancy could include because I don't think I could ever come up with an all-encompassing list, but it does include, what does include miscarriage care, postpartum care, lactation, just to name a few. So I just named a couple of them, but pregnancy does include those things and more.
Representative Scott.
Thank you, Madam Speaker, and thank you for answering that question. Would Representative Herr yield to another question?
She will yield. Representative Scott.
Thank you, Madam Chair. Representative Herr, so I agree with you. The statement is really broad. Including pregnancy could include a lot of things. Does this limit the state's ability to regulate and pay for surrogacy and fertility treatments? Could those be considered pregnancy under this definition?
Representative Herr.
Madam Speaker, Representative Scott, I hope so.
Representative Scott.
Thank you, Madam Speaker, and thank you, Representative Herr, for answering those questions. We had a pretty significant debate a couple weeks ago on surrogacy in this body, and right now it's the Wild West. And actually, the bill that was offered was also the Wild West as far as surrogacy. This will not change that. In fact, it might just be decided just by a bunch of courts and judges, not the legislature. Part of the problem with this whole amendment is we're abdicating our responsibility to the courts in a big, big way. So rather than proposing that we have a full-time legislature, we may not even need to be here maybe every other year, because everything's going to be decided in the courts. This is such an all-encompassing fruit basket of a constitutional amendment question. So thank you for the honest answers. I think we've got it on record that this could, and again, the public needs to know this, but this could and probably will mean that the taxpayers are going to be most likely on the hook for fertility treatments. And then surrogacy will be just whatever anybody wants it to be. And then we get into the baby selling and the womb selling. Please, please support the Rarick Amendment.
The member from Clearwater, Representative Grossell.
Madam Speaker and members, I look at the submission to the voters, the part that will go on the ballot if it goes there, and having having read statute for quite some time and being familiar with making sure that statute is clear, and I've known my colleagues, the majority of them, talk about having clarity, making sure that statute is very well understood. That everything that comes out of this chamber should be clear to whoever's looking at it, and to be able to articulate just what it means. And as I look at this this piece here, it's not clear. It's not clear. So if I were looking at this and being very, very pro-life as I am, I would probably vote yes to put this into the Constitution. Because, of course, I want equal rights. But then again, we all already have equal rights. Every person in this chamber has equal rights under our Constitution, has equal rights under our human rights statutes, everything. So in all actuality, this ERA amendment is not needed because we're there already, folks. We have equal rights, all of us. No matter what your orientation, sexual orientation is, no matter what your race, religion, we have equal rights. Now, I've worked hard to try to make sure that legislation that I put forward is also goes along with my faith beliefs. To make sure that that legislation, when I line it up with God's word, that it is a best reflection that I can have in front of me, that I can give to people, that I can share. And I know God's word is not confusing. It's not confusing. I know God's word is clear. But when I look at this does not, the submission to the voters is not clear, so therefore, it would not line up with God's word. To me, it would not line up. Because there's vagueness in there, there's a part in there that's being left out. That would be put into our Constitution, and it's something that I could not support, I would not support. And I know Representative Hurt has worked hard to make sure that when we're reaching across the aisle, working across the aisle, that does the best job that she can to make sure that things are done right. I know that. I've already seen that work being done. But the vague reference to pregnancy in this submission part, in the ballot question, to me is misleading and unclear, leaving voters uninformed about the true implications of the amendment. We all deserve, people deserve to know what they're voting on. And the way the ballot question is written, to me, is deceptive and does not tell the story of how expansive this new language would really be. Now, that is not questioning anyone, especially the author, because I know the work the author has done. That is not questioning the author's integrity at all. It is just that when a reasonable person looks at this, there's something missing here. And again, this language be added to the Constitution to enshrine the most extreme abortion policy in the nation and the world. Abortion up to the moment of birth, which most Minnesotans, about 64%, do not believe is right. Now, if this is clearly written and it is on the ballot, then okay. But make sure that it's clear. Make sure that what we do here, like God is not a God of confusion. God does not hide things from us. Makes it very clear to all of us. So I ask that you, again, like I said before, we all have equal rights right now, already. We all have equal rights. This ballot question is not even needed. Senate File 30, SF 37 is not needed. But I would at least ask you, if you're going to pursue this, take the amendment. Let's make sure it's clear. Let's make sure there's a very good picture of what people are looking at. Please support the amendment.
The member from Anoka, Representative Engen.
Thank you, Madam Speaker. After we adjourn tonight, I'm going to go and sleep on a cot at Children's here in St. Paul. It'll be a dark room, just myself and my son, who should still be in the womb, according to modern medical science. He's not at full 40 weeks gestational age. He's breathing on his own. He's eating on his own. He gets fidgety. He has all of the characteristics of a person who thinks. He feels things. When my hands are cold and I put my hands on him, he swats my hand away. And I run cold, so I always feel bad. I have to go run him underneath the sink and warm him up for him. He opens his eyes. He looks at me. He looks at the mobile that we hung above his crib. He's a person. And he's 34 weeks old today. 34 weeks, 1 day. If you're going to say that he doesn't have the fundamental right to exist, he can be ended, at least have the gall to say it. Because as I read this language, if I didn't read the rest of the bill, if I just saw the submission to voters, I'd want to vote for it. My family would want to vote for that. We don't want to discriminate against somebody because they're pregnant. But then you read the bill. On page 1, line 18, making and effectuating decisions about all matters relating to one's own pregnancy or the decision whether to become or remain pregnant. We're using your own language, your own definition in this amendment. That shouldn't be too much to ask. Clarity matters. Transparency matters. We represent people. We shouldn't try to mislead them. And I don't want to say that that's what you're doing, but that's what this does. It's what's been done in other states, and I'll give you kudos. It's been very effective there. Other states have passed this language overwhelmingly, and it's been pointed to and people say, ha, see, they do want it. And then you have a slew of people who come out a day, a week, a couple weeks later, they say, I didn't know I was voting for that. please, just tell us what you believe so that people can vote for it or against it, but make it transparent.
The member from Chisago, Representative New Brindley.
Thank you, Madam Speaker, and members. One of the things that has really bothered me about this unequal rights amendment is the lack of clarity in the language. Because, of course, in the actual constitutional amendment that's proposed, there are a lot more words than what is going to go on the ballot for voters. And frankly, this language, particularly regarding pregnancy, is really misleading. Particularly when you think of the history of women in the workplace, I suspect is what the vast majority of people will think of when they see the language, including pregnancy, that women shouldn't be discriminated against based on pregnancy. Every woman's mind is going to go to the history of women in the workplace and acts of discrimination against women, either not being hired for jobs because they are pregnant or could likely become pregnant, not receiving the same opportunities as men because they are pregnant or might become pregnant. That's what the average voter is going to think about when they see that language. Well, no, of course women shouldn't be discriminated against based on pregnancy. Of course not. Which is true. None of us think that should happen. None of us think that should happen. And it's just a more honest way of dealing with the public to say, instead of just including pregnancy, the decision to become or remain pregnant, which is exactly the language you want to enshrine in the Constitution. If that's the language you want to put in the Constitution, then that's the language you should put to the public. Let them vote on what you are actually putting in the Constitution. Because it may not be your intention to mislead, but the language misleads. It is not honest. And I also find it very interesting that we are hearing a lot of unknowns as we go through this amendment. We've had a lot of questions for the bill author about what different things mean. And we get a lot of, I don't know, maybe, it's a hypothetical, I hope so. When it comes to surrogacy, I hope so. And if the author of the constitutional amendment does not know what this constitutional amendment is going to mean for Minnesota, then perhaps we should at least make the language that is being presented as clear as it can possibly be. This is just one step in doing so because we've addressed a number of issues that are not clear, that we have not gotten answers for here in this chamber. But this is at least an opportunity to clarify that pregnancy is not talking about discriminating against a woman, not hiring her for a job because she's pregnant. That's not what this is talking about. This is talking about putting the most radical abortion policy in the world into the Constitution. That's what this language is about, so let's say that. This is about and in fact, we don't even say that. The proposed amendment is not even clear on that. The proposed amendment just takes your own language and puts it to the voter. The decision to become or remain pregnant. Why would we shy away from that? Why would we shy away from that? Is it because, I mean, I'm concerned. I'm concerned because the result of ambiguous language is poor decision making. When people don't have all the information they should have, they're unable to make good decisions. And interestingly, I suspect many people saw it. KSTP had a poll. I don't know, I've lost track of days. Was that just this week? Last week? I forget. Just this week. Just this week, KSTP released some poll results that 51% of Minnesotans do not believe that abortion should be in the Constitution at all. Over half of Minnesotans do not believe that abortion should be in the Constitution. And yet, the language that we are putting to the public, the language that we are giving to the voters, does not express to them that pregnancy means abortion. That's not, the language that we are giving to the voters is dishonest. Because if 51% of the voters knew that this language is about abortion, they would vote no. And what's the other number? 61? 64? 64. 64% of voters do not believe that the Equal Rights Amendment and abortion should be combined into a single constitutional amendment. 64% of voters do not believe that these two things should be tied together in the Constitution. 64% of voters. But frankly, if all a voter sees when they go to their ballot is, let's see here, race, color, national origin, ancestry, disability, sex, including pregnancy, gender, and sexual orientation. Okay, pregnancy, that's fine. They have no idea what they're actually voting on. They have no idea. This language is so dishonest. It lacks all transparency to the voter. You are asking voters to change the Constitution of the state of Minnesota. And you are not telling them the truth about what the amendment actually does. That is so dishonest. So the Rarick Amendment that simply changes the language of pregnancy to the decision to become or remain pregnant at least offers a little clarity, a little transparency on the decision people are making to change the Constitution, which will become the highest law of the land in our state, which will supersede any state laws that we write. Changing the Constitution is so consequential that we should take every precaution to make sure that voters have all the information they need to make an informed decision, to know what they are voting on and not just what the Democrats decide they get to know. Because this information limits their knowledge, and it is not right. This is not a good way to do business. This is not a way to deceive voters into voting for something that we know 64% of Minnesotans believe is a bad idea. They do not want to see these things on the ballot together. 51% of voters would vote against if they knew that's what this language means. But by tucking this in to the Equal Rights Amendment and just calling it pregnancy, we are deceiving voters. Because if we told them it was abortion, 51% would vote no. If we told them it was abortion and they understood it was tied to the Equal Rights Amendment, 64% of Minnesotans would vote no. This is so wrong. It is so dishonest. Take the Rarick Amendment and give some transparency to the people of Minnesota.
The member from Crow Wing, Representative Davis.
Thank you, Madam Speaker. Yeah, so I just want to read this quickly, and I know many have already read it, and I'll try not to be too long, but making and effectuating decisions about all matters relating to one's own pregnancy or decision whether to become or remain pregnant, but that's not the question that'll be on the ballot. The question on the ballot: shall the Minnesota Constitution be amended to say that all persons shall be guaranteed equal rights under laws of the state and shall not be discriminated against on account of race, color, national origin, ancestry, disability, or sex, including pregnancy, gender, and sexual orientation. That's the only thing the voter will see on the ballot, including pregnancy. So just thinking someone gets pregnant, yeah, they should not be discriminated against. That language right there, I read that, if I didn't read this whole thing, if I just read that, I would be deceived about the question on the ballot. And this ballot question, there'll be, if this makes it to the voter, there will be people who will vote yes for this, and then afterwards, if they actually looked it up, they would go, oh, I was deceived. Why would we do that? Especially when the intent of it is regarding abortion, ending the life of a human being in the womb. Think about that. They have a heartbeat. They have feeling. And don't tell me they don't, because my wife's been pregnant a lot, and we know they have feeling. We know it. And I know they have pain. My wife knows that too. They have pain. They feel pain in the womb. And boy, a baby will let you know when it feels pain in the womb. And this one too, and you might think this is ridiculous, but I know it's not. They communicate with their mother while in the womb. And many of you women in this room, you know what I'm talking about. And I can't really explain that one to you, but you know it. Somehow, some way, they communicate certain things to you. That human being in the womb. They have a heartbeat, they have feeling, they have pain, they communicate, and science proves that they have thoughts. And they get their oxygen through their mother. What a beautiful relationship between a mother and a child in the womb. What a beautiful relationship and dependence upon life between a child and their mother while they're still in their mother's womb. And I've heard testimony of people that have worked at abortion centers where they actually saw on the ultrasound while an abortion was being done that defenseless little human being, that defenseless little child, fighting and struggling for their life while the abortion was going on. And we're just going to put a question on the ballot. Don't discriminate against pregnancy. This language is very deceptive, and I'm probably not allowed to talk about on this House floor why, because I'd be impugning motives or something. But boy, I do have that question burning away in my heart, and my heart can't help bring up a bunch of answers. And they're not good. Why would we do this? This discriminates against children, babies, defenseless human lives. This discriminates against them. This is the most discriminating thing I can think of right here. This question on here, this bill for this amendment. We're discriminating against human beings to have the right to live. We're going to enshrine that in our, try to enshrine that in our Constitution. We got to change this. Again, I don't support this underlying bill, but I certainly do support this amendment. Thank you, Representative Rarick. For the sake of defenseless human beings in the womb, babies, children, let's light that board up green. You did ask for a roll call at the beginning of this, didn't you? Let's light that board up green, and I'll end with this, and then I am going to be done. I've already spoken longer than I thought I would. Again, I believe this is a voice coming from the womb. For you created my inmost being. You knit me together in my mother's womb. I praise you because I am fearfully and wonderfully made. Your works are wonderful. I know that full well. That voice is speaking of God. And it sounds like to me in Psalm 139:13, that very well could be a voice speaking from the womb to its maker. Thank you, members. Please, let's light that board up green.
Representative Rarick.
Thank you, Madam Speaker and members. We started this debate days and days ago, and one of the first things that was said was that we've been working on this for decades. And way back when, many days ago now, we had a DE. Leader Damath brought forth the DE, and that was what was worked on for decades. That was. This is not. This language is nothing like what our grandmothers fought for, what our mothers fought for. This is not that language. This is not my grandmother's ERA. This is not my mother's ERA. This is not my ERA. This language, if passed and goes into our Constitution, would enshrine the most extreme abortion law in the entire United States and be on par with some of the most extreme communist countries in the world. I ask you to support me in this amendment so that we can at least let the people know just a glimpse of what they're really doing. And support my amendment, the A12.
The clerk will take the roll on the amendment. Will the clerk please call the names of the members voting remotely?
Acom.
Acom, no.
Acom, no. Carol.
Carol, no.
Carol, no.
The clerk will close the roll. There being 62 ayes and 68 nays, the motion does not prevail. The amendment is not adopted. There is an amendment at the desk. The clerk will report the amendment.
Wolgamott moves to amend Senate File Number 37, the unofficial engrossment. The amendment is coded A23.
The member from Sherburne, Representative Wolgamott.
Madam Speaker, I rise as a proud ELCA Lutheran, a former church council member, and a longtime Sunday school teacher to present the A23 amendment, which would add religion to the list of identities and classes protected by the proposed Equal Rights Amendment. Madam Speaker and members, I've heard from previous discussions talk of other protections for religion in our state constitution, but we need to take a belt and suspenders approach to protecting Minnesotans from religious discrimination now more than ever. According to the FBI, anti-religious hate crimes have increased by 30% between 2021 and 2022. Nationwide, there have been 324 incidents of violence and vandalism against Catholic sites since 2020, and there were more than double that amount against the Jewish community in 2022 alone. And in my home community of St. Cloud, Islamophobia has reared its ugly head. We've seen troubling incidents of vandalism against local mosques, specifically at the Islamic Center of St. Cloud, which I know you've been to, Madam Speaker. It's a very sacred, very special site in our community, and unfortunately, we've seen it under attack based on religious discrimination. Again, members, we need a belt and suspenders approach to protecting Minnesotans from religious discrimination. That's why I'm bringing this bill forward, this amendment forward. I ask for your green vote.
Discussion to the amendment. Representative Nash.
Madam Speaker, before I begin my own debate, I would request a roll call.
Representative Nash requests a roll call. Seeing 15 hands, there will be a roll call. Representative Nash.
Thank you, Madam Speaker. I support the Wolgamott amendment, and I was informed that apparently mine is so much like it, it's going to get ruled out of order, so I'm going to speak as if this was my own amendment. We have all gotten a lot of emails and outreaches on this, and Representative Wolgamott, you mentioned some of the things that concern me as well, and I have been tracking the number of different religious beliefs that have reached out to me. And here are a few, because I think that many would like to believe that this is simply a bunch of evangelical Christians, of which I am one. I am proud to say that I have Jesus Christ as my Savior, and I believe that I am entitled to protection under an Equal Right Amendment, but we'll come back to that. But I think that many people would like to think that this is just Christians who are raising up a fuss over this, but I will tell you from the emails that I have gotten, they're not. So I looked and I talked to a number of them. I got a great number of emails from folks who follow Islam, Judaism, Buddhism. I got a few. I got several from who are practice the Mormon faith. I will take you to a conversation that I had with a person who used to be an Amish Anabaptist, so they are Baptist. There are atheists, Buddhists, folks who follow Shintoism, Sikhism, and Rastafarianism. I got one, so that was good. I agree. And it's not just Christianity, it's not just Catholics and Lutherans, and it's a huge selection of people who are people of faith who want to know that they are a protected class, as Representative Wolgamott said as well. And I'll take you back to when we began the debate, and I asked, I think I had the first question of Representative Herr, And her answer was, I would like to think, Representative Nash, that everybody would be equal under the law, but, and that's where I mentioned the but is an ellipsis for me, but they're not. And the rationale as to why we're having to have the Wolgamott amendment on this is still a mystery to me. So I guess I would like to ask Representative Herr if she would yield to a couple questions, Madam Speaker. Sorry, I don't ever usually do that.
She will yield. I don't get to be on any committees, Representative Nash.
I rarely do that,
Nash.
Madam Speaker, and you know that it bothers me, so I hate when I slip up. But thank you, Madam Speaker. And Representative Herr, Representative Wolgamott asked one of, or mentioned, or alluded to one of the questions that I have, and it's effectively anti-religious voices and activists are more and more on the rise, and they're getting louder every day. Is it your legislative intent that protecting people against religious discrimination is not a compelling government interest?
Representative Herr.
Madam Speaker, Representative Nash, I'm going to repeat what I said yesterday because that is still true today, that religious liberties are already protected within our state constitution. It is stated in our preamble that religious liberty is it's a core to our Constitution, and in Section 16 and Section 17, religion is protected. It has some of the highest protection in our country.
Representative Nash.
Thank you, Madam Speaker. Well, I guess, and I'm sure you've caucused this, I'm sure you've talked about this, and I'm encouraged that Representative Wolgamott has the guts to stand up and say that he disagrees with you on this. And I will be voting yes, Representative Wolgamott, and I would encourage all of my colleagues to do so as well. But let me ask if Representative Herr would yield to another question, Madam Speaker.
She will yield. Representative Nash.
So let me take us down this path. Representative Herr, is it your intent that gender identity should receive more constitutional protection under ERA than religious practice? And I'm asking, relative to your ERA proposal, why is religion not in there, and why does it seem that gender identity would receive more protection under ERA than religious practice?
Representative Herr.
Madam Speaker, Representative Nash, no one receives more or less. They all will receive strict scrutiny. Religion is already protected under our state constitution.
Representative Nash.
Thank you, Madam Speaker. Well, I'm going to take us back to what I just reminded the body of just a minute ago, because you said it yesterday. I, Representative Nash, would like to think that everybody was equal under the law, in your words, but, my ellipsis, apparently they're not. Apparently they're not. So, to Representative Wolgamott's point, apparently my heartfelt religious beliefs are not worthy of being included in the ERA, and I'm deeply confused by that. Why religion is not considered a protected class in ERA. And I have listened a lot. I'm an attentive listener, and I write a lot of things down. And I hear regularly all about DEI, diversity, equity, and inclusion. Well, guess what? This is neither diverse. This is not equitable, and it is not inclusive if you are leaving religion out of this. Practice what you preach. Put religion in, and show that your legislative intent is to provide a good level of protection for heartfelt religious beliefs as a protected class. I am very, very confused by this, and I am glad that I can provide you comedic relief, Representative Herr, as we laugh in this debate. I don't see why, in something that is titled an Equal Rights Amendment, why you would I don't know what your intent is with Representative Wolgamott's amendment. But why would we not include religion? Because you've included a great many other things, and in debate yesterday, it felt like 3 days ago, but in debate yesterday, you also had mentioned other things in other parts of law that are covered, but you're putting them in here because you want them to have extra protection. Well, here's your chance. Here's your chance to say, you know what? Belt and suspenders, Representative Wolgamott said, belt and suspenders, let's do that. It's simple. It's simple. Representative Wolgamott is merely inserting the word religion after a comma. Woo! That's tough. That's hard. I sounded a little bit like Ric Flair there. I know. Sorry. It's a simple process. You can do this without any difficulty. You just push the button green, do the belt and suspenders pathway. But I'm confused because the legislative intent here seems to be that you don't think that we should be included. Now, let's get back to Jim Nash. When I was 14 years old, I accepted Jesus Christ as my Savior. And I will tell you that that is a pivotally important thing in my life. Earlier today, we talked about some things, and I'm not going to get into it because I don't want to fall apart again, but it is only because of my faith in Christ that I was able to make it through all of that hell that I lived as a kid. And I would like to think that my own state of Minnesota here would recognize that that faith of mine that is so vitally important should be a protected class. And we've already seen in recent legislative time, that in the lawsuit that Crown College and others are involved in, that there is a decidedly anti-religious bent of our own state. So as somebody who represents the Crown College as a trustee, I would like to think that now my own state would say, well, we're going to make this a protected class. Stand up and do the right thing and say, people who are of great faith, and I listed off a great many of them. I can list more. I left out Jainism. That was another person that I tracked down. It's such a fundamental thing. And I'm confused by the legislative intent because it seems to be decidedly against people of faith. That the exclusion in this amendment that you wish to put on the ballot would say people of faith don't matter. That people of faith are not worthy of being a protected class. Incredibly troubling. Because as I drive through Carver County, I know a lot of people who are of deep, meaningful faith. Great Catholics and Lutherans and Baptists. People of all types of different faith. Jews in my area, they're very concerned about this legislative intent that seems to be being created, that folks who are of these faiths are not worthy of being a protected class. So, Representative Wolgamott, you have my guarantee I'm going to be voting green on your amendment. It seems like it's a practical thing. It doesn't seem like it's a difficult thing at all. It seems to me very common sense. And I would hope that for as many times as I have seen your caucus band together with you and others on amendments, that they would do the same. Vote green.
The member from Ramsey, Representative Pinto.
Thank you, Madam Speaker. Members, I rise in opposition to the amendment, and I want to first get this out of the way that as with Representative Nash, I recognize the leadership of Representative Wolgamott. You stand on principle always. You fight for your constituents. I know that you're doing so now as well, so this is not any disrespect to you, sir. Having said that, what I'd like to ask, it's 1 in the morning, but if folks could please look for your blue state constitution. If you're watching online, we may have some folks doing that. There's been a lot of references to our state constitution. I think folks, as you're doing that, I think we're pretty familiar with our U.S. Constitution, so maybe we'll run a little quiz. Think, where is our protection of our religious liberties in our U.S. Constitution? It's in our First Amendment. Hopefully it makes sense to folks. The right of our free exercise. That is a federal constitutional right, very important. Of course, this amendment would not touch that federal constitutional right. I'd like to ask, as you bring out that blue book, if you can identify, we've said it a bunch of times in the course of this, as to where your state constitutional right to religious liberty is. Where is that? That is in Article 1, Section 16. We're less familiar with that, though maybe folks have been following along. If you could turn to that, folks, I would appreciate that. It's on page 4 of the Blue Book, and folks looking online, you can Google this, of course, at 1 in the morning. That's still available to all of us. And if you look, the right of everyone to worship God according to the dictates of his own conscience shall never be infringed. That is the language of our state constitution, not touched by this amendment. And nor shall control of or interference with the rights of conscience be permitted. Control of or interference with our rights of conscience shall not be permitted. That's in the state constitution, not touched by this amendment. And members, and there's reference to religious tests, Representative Hur at various points has alluded to this. Now, so have that in mind. That's very, very detailed. You compare that to our amendment we're proposing, fair enough. I'd like you to look in that amendment then, Representative Hur has pointed this as well, lines 2.7 to 2.8. People may not have copies of this, but hopefully you got that online, that this amendment does not limit or narrow existing rights in this Constitution. Does not do it. At various points during this debate, I've heard folks say, oh, this is going to be eliminating rights, destroying rights. The very words of the amendment that will be before us once we make it through these amendments, the very words of the constitutional amendment make clear this does not limit or narrow existing rights in this Constitution. So let's make sure we're very clear on one thing, which is that we have religious liberty under our state constitution, our federal constitution. That will not change if this constitutional amendment passes. But there's more. As has been alluded to, those rights under the state constitution have been interpreted by our state courts to be more protective than your federal rights. Go to another state, you have less protection for religious liberty than you do in the state of Minnesota. That's not being touched. Our courts have interpreted to be a higher level of protection. Let's have that in mind. Now, that might say, well, we have these rights. Why not toss it in? We're wearing a belt. Why not put on suspenders? First, let's just point out, this is our foundational document, okay? I'm an attorney like many others. You're writing a contract, you don't kind of toss in a bunch of extra phrases just for the heck of it, right? Things have legal meaning. You want to be very careful what you toss in. Personally, I'm pretty thrilled with my right and yours that there shall be no control over interference with my rights of conscience. And I'm happy that that's true for you as well. That's not going to be touched. You start tossing other things in, I start getting concerned about exactly how that ends up working. We have our religious liberty. Now, I will say I don't see in this document references to the other portions in SF 37, to race, color, national origin, ancestry, et cetera, that we want to make sure are protected. Those are not currently protected. That's why Representative Hur is proposing that they be protected. Religious liberty is protected. That's why it's not in the amendment. But again, why not belt and suspenders? Well, I just want to make sure we're thinking about this clearly. Is it religious equality that we are looking for? Do we want to have the various faiths that Representative Nash outlined? Do they all get treated exactly the same, or is it religious liberty that we are looking for? Is it the freedom to practice our religion and to follow our conscience? The freedom to have, again, no interference with our rights of conscience. The freedom to worship God and to not worship God according to our dictates of our own conscience. That's what we're looking for. So I would just say, I think we want to be really careful about saying we're looking for equality of religion. I don't know that that's exactly what we're looking for. We want freedom, right? We want liberty, religious liberty. Section 16 of Article 1 is drafted carefully with a lot of detail to talk about the balance between our freedom of conscience and between, because of course we have generally applicable laws, and how do we balance those things out? Minnesota law comes out of our Constitution and has said, we're going to actually be pretty aggressive about protecting those freedom of conscience, much more than under the federal Constitution. Members, that has served us really, really well. We don't want to commit the category error of sticking an additional piece in this equal rights amendment. We're not looking for equal rights. We're looking for religious liberty. We're looking for the chance to have each of us practice our faith. I share the Christian faith of a number of folks who've spoken. I do. We have colleagues who share a number of the other faiths that Representative Nash stated. I think for many of us, that's why we're here. That's why we're doing this work at 1 in the morning, is because of our faith. That's true of many of us. And for many of us, it's not our faith, specifically in a divine being, that drives us to be here. It's other beliefs about the universe and our place within it. We all have that freedom of conscience. Members, that's what we're looking for, is that freedom of conscience. That's protected in our Article 1, Section 16. I think we want to be really, really careful about sticking additional words in our foundational document when we have a section that's working so very, very well. Let's provide equal rights in these categories that are not currently provided, and let's make sure then that we have our constitutional protections for religion, for our freedom of conscience, that are already in our Constitution. And boy, we do not want to make that mistake. So members, I would urge respectfully to my colleague, Representative Wolgamott, I would urge a no vote on this amendment. And let's be grateful for the freedom of conscience that we have. This amendment, this constitutional amendment is not going to threaten that. But it's possible that this amendment would. Vote it down. Thanks.
The member from Anoka, Representative Niska.
Thank you, Madam Speaker, and thank you, Representative Wolgamott, for this amendment. And I appreciate the discussion that's happened so far. I especially appreciate, Representative Pinto, your ode to the care that we must take to writing new language in this foundational document. I look forward to your no vote on this underlying bill when we get to that point. I can't imagine you would vote for a bill for this kind of a radical change to our Constitution after less than 2 weeks from its first committee hearing. So I look forward to that conversation later. But Representative Wolgamott, thank you very much for at least trying to stand up for what's really one of the most fundamental American values, Minnesotan values, our freedom of conscience. It is right there in the preamble of the Minnesota Constitution. We, the people of the state of Minnesota, grateful to God for our civil and religious liberty and desiring to perpetuate its blessings and secure the same to ourselves and our posterity, do ordain and establish this Constitution. That is one of the fundamental purposes of our Constitution, is that we are grateful to God for our civil and religious liberties. And our Constitution, make no mistake about it, already maintains that all of us are equal. In Article 1, Section 2, it says, "No member of this state shall be disenfranchised or deprived of any rights and privileges secured to any citizen thereof, unless by the law of the land or the judgment of his peers." And our state Supreme Court has interpreted that to be an equal protection clause, just like we also have an equal protection clause under the federal Constitution. And it is true that we have a First Amendment to the U.S. Constitution, and we do have some free exercise protections under the Minnesota Constitution. And current Minnesota case law, again, we've heard a lot of discussions about how current Minnesota case law might change in the future. Current Minnesota case law is very protective of free exercise. But Representative Wolgamott, you are absolutely correct that we need to take this additional step to make sure that we not only protect free exercise, but that we protect very clearly and very explicitly non-discrimination against religion. You're right, Representative Pinto, that those are two slightly different, though related, but slightly different categories. And we have one very clearly spelled out in the Minnesota Constitution. But if we pass this amendment without the Wolgamott amendment, we won't be spelling out the other one. And Representative Wolgamott is absolutely right. That is especially important in this time of hostility towards many faiths, violence against Catholics and Catholic churches, violence against our Jewish community, violence against our Muslim brothers and sisters in this state, violence against many different faith communities. And we need to be clear that when we're talking about creating and clarifying the compelling state interest that the state of Minnesota has in protecting Minnesotans against discrimination, that compelling state interest includes discrimination on the basis of religion. If we're going to list a bunch of other categories, we have to be very clear. There is discrimination, there is hate that happens on the basis of religion, and if we're going to call out the other categories, we have to be very clear that it covers this as well. Because if we don't, we leave the door open for, again, that future case law to develop in ways where judges might think that what we're saying is that it's not important. And I'm really concerned because I'm not hearing a good reason why not to do it. I'm not hearing a good reason why not to do it. And so Minnesotans are going to be left to wonder, why? Why is the majority voting against it if that's what happens here today? And judges who are going to interpret this down the road are going to have to understand, are going to have to ask that question as they try to interpret how these different constitutional provisions fit together. And it is going to erode religious liberty if we pass the underlying amendment without making clear that we are also saying that the state of Minnesota cannot discriminate on the basis of religion, has a compelling interest to protect discrimination even in effect on the basis of religion, alongside of all of the other things, including, for example, gender expression, right? We're talking about essentially speech in one area. The state of Minnesota is going to be told you can't discriminate, even in effect, on the basis of gender expression. But if we vote down the Wolgamott Amendment, we're not saying the same thing about faith. What are the courts supposed to make of that? And we've heard discussion about concern that some of these provisions in here are imposing a worldview, a controversial worldview on Minnesotans on a lot of these issues, including Minnesotans who don't agree, many because of their faith. We had a long discussion about what a state actor is under this. And there are concerns that the failure to clarify and tighten that definition of state actor means that some of these provisions are going to apply against faith institutions. In fact, the state of Minnesota is already arguing against two faith institutions that they are state actors. So if we don't make clear that non-discrimination principle also covers religion, what are courts to make of that? This, Representative Pinto, you're right about the current case law to an extent about what the Minnesota Supreme Court has said. And Minnesota has a proud tradition of supporting religious freedom. The U.S. Supreme Court, in a case that I disagree with called Employment Division versus Smith, it's one of a few Justice Scalia, one of his worst majority opinions, to be frank with you, said that the free exercise clause of the U.S. Constitution doesn't cover generally applicable laws that it might incidentally burden religion. And Minnesota had a case that was up from the Minnesota Supreme Court at that same time. It was sent back for reconsideration in light of that Employment Division versus Smith case. And in that case, Hirschberger, the Minnesota Supreme Court said, that's interesting, Justice Scalia, what you say about the First Amendment of the U.S. Constitution, but our Minnesota Constitution is stronger, and we have a proud tradition that we apply strict scrutiny. But strict scrutiny means you look at what is a compelling state interest and what's narrowly tailored. And we're now enshrining into our Minnesota Constitution additional compelling state interests that might infringe on someone's freedom of speech or freedom of religion. So it's important that we do clarify that we are not watering down free exercise rights, and in particular, that we are making clear that the equal protections, the freedom from discrimination protections that we're applying here, not just free exercise, but freedom from discrimination protections, which have different remedies, which have different tests, that also applies to all faiths as well. So thank you, Representative Wolgamott, for this amendment. I will certainly be supporting it. I hope that everyone in this room, everyone who stood up on their first day here and said that you were going to uphold the Constitution of the state of Minnesota, which is ordained and established for us, the people of Minnesota, grateful to God for our civil and religious liberties and for perpetuating its blessings to ourselves and our posterity. I hope we will make clear that the non-discrimination principles that already exist here, but if we're going to clarify them and make them longer and add more words to them, we certainly should clarify that covers people of faith as well. Please vote yes on the Wolgamott amendment.
The member from Crow Wing, Representative Davis.
Thank you, Madam Speaker. Representative Wolgamott, thank you for this amendment. And in a moment, I'd like to tell you why this amendment means so much to me. Truly thankful that you brought this forward because you sit in the majority. Representative Nash, I would also not only like to honor and thank Representative Wolgamott for this amendment, you had this amendment as well. Thank you for bringing this amendment, Representative Nash. It is very important, Representative Pinto, about being careful about what words we stick in our foundational document. That was my argument on the last amendment. I won't bring that up because I'll get ruled out of order. You kind of made my point for me. Again, I'll come back to what Minnesotans are going to read, and I hope to change your mind, Representative Pinto. I truly do. They're going to read, shall the Minnesota Constitution, I won't go through the whole thing, but shall not be discriminated against on account of race, color, national origin, ancestry, disability, or sex, including pregnancy, gender, and sexual orientation. That's what they're going to read. And what they're not going to read in that question is religion, right now, as is, if this indeed does go to the voter. Why would we not submit one word just to be thorough and to make sure and put the importance in the question on the ballot of not discriminating against something? One little word, religion. And why does that word mean so much to me and so many others in this state? See, prior to me becoming a Christian, I was an atheist. And I hope I'll be allowed to tell my story because many have been allowed to tell their story, and it's a great honor for me to be able to tell my story over why this is so important to me and why I support it. Because I do hope to convince you that though I don't support the underlying bill, I absolutely support your amendment. And again, hope to light up this board green. That word religion you see before Christianity, I had a religion called atheism. And you might think that's not a religion. Oh, yes, it is. I could debate and argue that a few different ways. See, your religion is your worldview. It's what you view the world through. I viewed the world as through the eyes of an atheist who hated the name of Jesus, I had a hatred in my heart towards Christians and towards religious people. I really did, because I had great misunderstandings about religious people. Not all of them, but many of them. And you see, me as an atheist, I did have a God. Me. You see, I didn't want... The reason I was an atheist, and I found out this is why many are atheists, not all, perhaps, but I'm just saying for me and others. The reason why we had the religion of atheism was because we didn't want God telling us how to run our lives. I was the God of my world as an atheist. I was my God. So I had a religion. And my life absolutely spun out of control with me playing God in my life. I was an addict. I was full of hate. My wife at that time was ready to divorce me. And then at work one day, I got stuck working with the Christian. That's the way I tell that story. I got stuck working with the Christian. And he wasn't a perfect man, but he was the real deal. He lived out his faith before me. And I realized, man, there is something different about this guy, Representative Nash. I could tell by his walk with Jesus Christ, as you attested to. There was something different about this guy, and wow, what is it? And later on in that day, or over the next few days, I kept working with him and building a relationship with him. And then the weekend came, and we came back on a Monday, and he presented the gospel to me. He told me that Jesus had died for me. He told me that God had raised him from the dead on the third day. I remember this. He looked at me with love and compassion. He looked me right in the eyes, and he said, "Ben, where are you going when you die?" And when he looked at me and he said that to me, I felt like God was staring right into my soul. Representative Wolgamott, I honestly do. I feel like God was staring right into my soul. And I looked at him and I said, I know where I'm going. I'm going to hell. No, that was just me. That was my testimony. I just knew it. And he looked at me with compassion and he said, it doesn't have to be that way. Jesus Christ paid a great price for you by dying on the sin as the Savior of this world. And a few hours later, as Representative Nash already testified to this, I surrendered my life to Christ. I said a prayer and I asked Jesus Christ to come into my life. And boy, did he. I found out Jesus is alive. And my life turned right side up real quick. Not overnight, and I'm still not a perfect man, far from it, Representative Wolgamott. I got a long ways to go. But boy, my life started to change. And I experienced the power of God through his son, Jesus Christ. That's why this amendment means so much to me. Because Jesus is alive and he absolutely changed my life. And I give him all the credit and glory for even being standing here before you right now. So I thank you for this amendment. And let's please, or I thank you for this, yes, for this amendment. And I ask, please, members, that we would stick this one word in on the Wolgamott Amendment, on the Nash Amendment. Stick this one word in, please. Thank you.
The member from Isanti, Representative Johnson.
Madam Speaker, members, Representative Davis, that's a hard act to follow. But why is this important? Yes, our Constitution of the United States grants us freedom of religion, not from religion, of religion. And with that religion, it states, or with it in the bill, it states we can't discriminate like everything else because of that religion. We saw a lot of discrimination on religion the last few weeks at our college campuses across the country and at the University of Minnesota. hatred towards those of our Jews and our Jewish faith. It was absolutely sickening watching what was going on. And then our university capitulates to those spreading that hate. Those individuals at that college campus have paid for and have a right to the education they paid for. But they were mostly locked out, afraid to go to the campus, to the school of this state of Minnesota, the university. Afraid in deep fear of harm. And the university did nothing. That's why this is important, to protect those kids. Protect each and every one of us against that discrimination that was shown so vividly at the university. Yes, freedom of religion is in our Constitution. But this amendment is about discrimination, not freedoms. This bill we're talking about is about discrimination. A few weeks ago, actually a month or so ago, maybe 2 months now, in the judiciary hearing, when we tried to put religion into the human rights bill, we were told it was intentionally left out. Shows where the priorities are.
Representative Johnson, I'm going to ask that you keep your remarks to the amendment and not go to motive. Representative Johnson.
Madam Speaker, it is. Because this is why it's important to be in there. We fought to get it in that bill. We did. And we're fighting for all religions now to get it in the bill so they cannot be discriminated against. Representative Wolgamott and Representative Nash, thank you for your amendments to put religion in. Please vote for this amendment.
The member from Chisago, Representative New Brindley.
Thank you, Madam Speaker and members. So a year and a half ago, I I attended a presentation on religious freedom. There was somebody in town from Texas who is sort of an expert on the issue of religious liberty. And it was an interesting presentation. I had some time to talk to this attorney afterwards, Stephen Collis. And it was interesting. We had a conversation about Minnesota specifically, and actually how Minnesota has traditionally been a reasonably good state when it comes to the freedom of religion. And in fact, he noted that during the pandemic, actually this was on a previous call with him, he noted that during the pandemic, Minnesota was actually good because we opened up our churches with other businesses that were allowed to open. And I thought, well, that's a little revisionist history. Because of course, the governor's executive orders actually kept our churches closed until God bless the Catholic Church said, we are going to open. Whether you say we can or we can't, we are going to open. We will exercise our right to freedom of conscience. And God bless the Catholic Church, because they're actually the ones that got churches open during the pandemic. So a little revisionist history on that. But what that tells me is that our protection and religious freedom is not complete. And in fact, throughout this legislative biennium, we have seen a continual attack on religious liberty. Over and over and over again. So no. What is in the Constitution already is not sufficient, actually. And I went to Article 1, Section 16, and in fact, I think my note-taking was just ahead of Representative Niska's speaking, but I went through the entire amendment. The right to worship according to the dictates of our own conscience. We have the right to worship. We can't be compelled to worship. We can have no control or interference with our rights of conscience. No one gets to tell us what to do when it comes to our rights of conscience. No preference or establishment of religion. We're not going to have a state religion. We also can't use religion as an excuse for bad behavior. And no public monies going towards these things. In that list, there is no protection, there is no explicit protection against discrimination based on religion. And these things are treated differently. I subscribe to a faith that, frankly, I think in many circles it is one of the few faiths that it is still acceptable to mock. There's a whole Broadway play mocking my religion. It's celebrated. It's hilarious. So it does matter. I know that I've got my rights to conscience. I also want my right to not be discriminated against. And I think my Jewish friends and my Muslim friends want that same right. And my Protestant friends and my Catholic friends. Again, God bless the Catholic Church for standing up and demanding their rights. All of our rights. But make no mistake, what is in Article 1, Section 16 is not the same thing that we are putting in, where's this going? Section 18. It's not the same thing. It is absolutely not the same thing. Not only do I want freedom to worship according to the dictates of my own conscience, I want equal protection under the law based on my religion. I want freedom from discrimination. And I want it to be very clear that freedom from discrimination is equivalent to race, color, national origin, ancestry, disability, sex, including the decision to become or remain pregnant, gender, and sexual orientation. I wanted to be clear that my religion is protected from discrimination along with all of those other things, in addition to my freedom to worship according to the dictates of my own conscience. And frankly, if the majority believes, which is what was said earlier, that, well, hey, this is no big deal, it's already in the Constitution, we don't need this, well then great, let's just throw it in here. That's a really easy solution. Because one of two things is true. Either this amendment is unnecessary and meaningless, or it is so meaningful that we're going to say, no, we don't want it. It can't be both ways. It cannot be both ways. It is either meaningless, in which case, great, add it in there. Because that will give a lot of people across this state a lot of comfort, knowing that their religion and discrimination based on their religion is protected just like all of these other things. That will give a great deal of people a lot of comfort knowing that. So if it doesn't matter, let's throw it in. But if you vote no on this amendment, that tells me that you think it does matter. That tells me that you think there is a difference. Because if there wasn't a difference, there's no reason to vote no. Literally none. There is no reason to vote no if you think that this explicit protection from discrimination is already there. There is no reason to vote no. So let's make sure that Minnesotans have a chance to look at the Equal Rights Amendment and make no mistake, the Wolgamott Amendment will make it more equal than it currently is. If your belief is that the Wolgamott Amendment really doesn't matter, it's already there, then let's vote yes. And let's give Minnesotans some peace of mind. When they look at this amendment on the ballot, that they see this and they know, oh, hey, my religion, I will not be discriminated against based on my religion. Let's give Minnesotans that peace of mind. Let's make sure that they know that they will not be discriminated against based on their religion. Let's just vote yes. Let's just throw this in. Let's just throw this in. Thank you, Representative Wolgamott, for the amendment.
The member from Olmsted, Representative Quam.
Thank you, Madam Speaker. Members and citizens watching, equal rights for all is different than equal rights for those on your list. When we do laws and make something legal or illegal, it's for everybody unless we list specifics. We call out specifics. And frankly, there's no reason why, if we all agree it should be protected, that it's not included. The idea that religions, beliefs are universally protected in our Constitution is not factual, because there's differences. Forcing a person to do something is different than preventing a person from doing something. If you force a person to do something that's against their religious beliefs, you shouldn't be able to do that. We used to have religious exemptions. However, those religious exemptions disappeared in too many cases in recent years. So again, equal rights for all means for all. But once you start delineating groups, then there's a different emphasis. And frankly, that's why we want to say, hey, we want to make sure that we include religion in this amendment. I have not heard one reason to exclude it other than it's already there. And frankly, I just gave the examples of why it should be included, because once you in law or anywhere make a list, you're specifying to that list. So once again, equal rights for all is different than equal rights for those on your list. Please include religion to our list of equal rights given.
The member from Douglas, Representative Franson. The member from Sherburne, Representative Lawrence.
Good morning, Madam Speaker. I think it's very fitting that we have a chance to discuss this topic on Sunday morning, 2 a.m., almost 2 a.m., according to what it looks like on the clock. And in a few hours, many of us would normally be home, be getting our kids out of bed maybe, or getting cleaned up and heading to church this very day. And so how appropriate that we get to talk about religion on this Sunday. Representative Pinto, I want to thank you for pulling out the Constitution, asking us to go through it with you and walking through an explanation there. I really do appreciate that. I've read through that numerous times. You taking me through it one more time was very beneficial, and I'm grateful for that. And we've heard over the last few days here that Representative Pinto, Representative Herr, that both you have referred to Section 16 here as being it's already covered. It's already covered. And so, members, if you're in question about how to vote on this, I ask that you just take a moment and reconsider. Because based on what we've talked about and the explanation that I've heard from Representative Pinto and reading through it over and over again, Section 16, I'm very grateful for. I'm grateful that it exists in our Minnesota State Constitution. It serves an extremely important purpose there, but it's not the same purpose. The purpose of Section 16 is that it gives every one of us the freedom to practice religion. It doesn't infringe on our freedom to practice religion. It says that we can't be denied our freedom to practice religion. It is a section that grants us the opportunity to practice. It ensures that opportunity to take action. Right? It's an action statement. We have that opportunity to practice religion as we've been called to do, in the faith that we've been granted. And so I see it as very, very differently from Section 16 to what we're talking about tonight. In the constitutional amendment that we're talking about, it states very clearly, the state shall not discriminate. Now that's a whole different game. That's a game changer. That the state cannot discriminate against, I talked about the list the other day, right? We're going to miss something out of the list. We talked about age. Today we're talking about religion a little bit. But the state shall not discriminate any person in the intent or effect on account of one or more of the following. Let's just put religion at the first one. The state shall not discriminate any one of us based on our religion. It's not granting me a purpose, but it's saying something completely different. And that's why it's so important that this morning, not tonight anymore, this morning, that we move to adopt the amendment that's before us. I don't remember the number. Amendment number 23. Amendment number 23, and put religion in here. Because there's two different things. And I just ask you, read the amendment again. I read it numerous times. I went through it over and over and tried to dissect it. And it wasn't until tonight that as going through with Representative Pinto, that it was like, hold on, I think I see something different here. Read the constitutional amendment. We're asking two different questions here. And the question tonight is to put Amendment 13 in here. Vote yes on Amendment 13. Add religion to the Section 18 here as one of the things that a person in the state of Minnesota cannot be discriminated against from the state. Thank you, Madam Speaker.
Closing argument, Representative Wolgamott.
Well, thank you, Madam Speaker. And before I get into my closing comments, I just wanted to double check that a roll call has been requested on this.
It has. Representative Wolgamott.
Okay, thank you, Madam Speaker. I recently saw a survey that showed that almost 80% of Minnesotans identify as religious. The A23 amendment is for them. It's also for the 20% of Minnesotans who don't identify as religious. This amendment is for those who worship with my family at Bethlehem Lutheran Church, who worship at the Islamic Center of St. Cloud, who worship at any of the number of religious places of the faith that Representative Nash shared with us earlier. Madam Speaker, this amendment is for those Minnesotans so that it can be the question on the ballot that the state shall not discriminate against them in intent or effect on account of their religion. That's who this amendment is for. Thank you, members, for the conversation. On behalf of faith-filled Minnesotans, I ask for your green vote.
The clerk will take the roll on the amendment.
Ash withdraws it.
Yep. Okay. And he's going to withdraw, but in a second. Will the clerk please call the names of the members voting remotely?
Acom.
Acom votes no.
Acom, no. Carroll.
Carol, no.
Carroll, no.
The clerk will close the roll. There being 63 ayes and 67 nays, the motion does not prevail. The amendment is not adopted.